Good morning, ladies and gentlemen. I'm very glad to greet you here on the third open day of the Data Protection 32nd Data Protection Authorities 32nd Spring Conference. Maybe for those who join us today, I will a little bit explain about this conference. This conference is a rather long tradition for the data protection authorities to gather together in a spring in order to discuss challenges, possibilities, and directions how we go within the personal data protection regulation and implementation. And then couple of the years, it was proposed that it would not be only closed conference for the data protection authorities, but we could add as well the open days where the public can join discussions of the data protection authorities, be in this discussion, and as well get new knowledge. And so for this year, the Spring Conference is organized in Riga, and this is the first time that Latvia is organizing this conference. Our previous 2 days, and I would say the motto of this year's conference was cooperation, information sharing, and working together. Because data protection, it's a very global thing. We cannot think about it only on the national level because we have electronic platforms, we have our devices, everything which connects us together as in the world, but in many cases it then becomes harder to get control of this data or get some unique regulation because it's cross-border. So that means that we need, to the future, we need to cooperate more and we need to understand each other more. What we have seen as well, each of us who works in the different areas, data protection authorities or data protection officers, specialists, we work in the data protection. And you know, as this is like new social, not event, but issue that we all in some kind of bubbles. So we data protection officers and data protection authorities, we are in our data protection bubble. There is another areas, I would say, for example, banks, they are in their banking bubble. And there is one other thing, like anti-money laundering thing, which is another bubble. And so we all live in our bubbles. But what happens when we are in the bubbles? We do not see the clear picture, we do not see the wider picture. That's why for the today and for this open day, we chose to connect these bubbles. Because, you know, there is 4 very important and known letters in the word GDPR. But I would say that there is another 3 letters that is well known is AML. And 2 of them are cross-border because it's not only on the national levels, it's cross-border because each country has their own regulation on the data protection. Each country has their own regulation on how to secure the financial sphere and financial transaction. So that's why for today, and today we will have 2 panels. Within these panels, we try to combine AML and GDPR. So those persons and people who works in the GDPR world, in the data protection world, would hear what purposes, what challenges, or what aims are within the world of AML. And as well the AML people, because it's not only here, this place that we are here, we are also online, so everybody can join us, and well, so those people who work in the different areas can understand and what does it mean data protection, why it's important, and how we can combine data protection and anti-money laundering, saying that maybe there is no, so many challenges, or we can resolve all these challenges if we work together. So for the first panel then, we have a name, Navigating the AML Regulations and GDPR Challenges, Cooperation and Compliance. And for this panel, I would ask here on the stage and on the floor the moderator of the panel, Lasma Dilba, who is the Deputy Director of the Data State Inspectorate of Latvia. Please applause. And then our respectful lectors and presenters who will be participating in this panel, Anne Neville, and Anne have to be online, Michelle Frasher, Nick J. Maxwell, and Anders Cengrevich. Please come to the floor. And now I give the floor to Lasma and I wish you productive discussions. Thank you.
Hello, everyone. Very warm welcome here in this fabulous place. It's, if you don't know yet, it's Lielā Mežaparka Estrāde. And we can start today, and one of our experts will connect with us remotely. And what about today's stories and today's discussion? Anti-money laundering and data protection regulation often clash. Why? Because one demands information about individuals and other requires protection of snipping eyes. And it creates a dilemma because staying compliant with both easier said than done. The introduction of the new EU anti-money laundering framework marks a pivotal moment in the regulation of financial activities within the European Union. With heightened emphasis on data protection, this discussion will explore the balance between ensuring compliance to the AML and safeguarding personal data. I'm honored to have an opportunity to participate in this discussion with such distinguished experts. And I would like to thank experts for being able to find time to come here in Latvia and to participate in this discussion. Believe me, all today's experts' bios are really impressive, and I encourage you to check out more in our conference webpage. Therefore, to save precious time, I will give a brief overview of each expert's experience before giving the word to the presentation. Okay, let's start. Our first expert is Miss Anne Neville, and I hope we can see her.
Hello.
She is here. I need technical support, I think. Okay. And are you here? Can you hear us?
Yes, I am.
Okay.
You can hear me? Good morning, Rika.
Good morning. It's okay, yes. And Ms. Anne Neville is a policy officer at the Financial Crime Unit of the Directorate General for Financial Stability, Financial Services and Capital Markets Union, DG FISMA at European Commission. She is the second national expert from the Department of Justice in Ireland. She has also worked in the European Parliament Research Service, and she is a barrister specializing in white-collar crime. She will tell us about the essential role of personal data in AML compliance. Good morning one more time, and you can start. Thank you.
Thank you. Good morning, everyone. Today I'm going to talk about the interaction between AML legislation and the protection of personal data, focusing on the new AML package, which will enter into force this year. My presentation will discuss the following: introduction to the package and its structure, the AML package's approach to the handling of personal data. I will focus on the safeguards for personal data provided by the package, And finally, I will discuss two areas where concerns have been raised about the processing of personal data under AML legislation. They are the Sovium case and the introduction of partnerships for information sharing. So, starting with why the need for reform of the EU's AML regime. The current legal framework is based on a directive which requires transposition by member states, leading to an approach to AML that is determined at national level. So the rules are implemented in a way that is not fully consistent with the needs of an integrated internal market. The new AML package replaces the directive with a single rule book consisting of a directly applicable regulation which provides rules for the private sector. It also has a directive addressed to the member states with more detailed rules on beneficial ownership registers, the responsibility of the financial intelligence units, the FIUs, and AML supervisors. The package also sets up a new AML authority, AMLA, which will directly supervise the riskiest financial institutions in the internal market, while at the same time promoting supervisory convergence among national supervisors. Finally, the package amends the Transfer of Funds Regulations recast to impose an obligation on the crypto asset service providers, the CASPs, to collect and make accessible full information about the sender and beneficiary of transfers of crypto assets in order to ensure their traceability. The package is based on the twin pillars of harmonization and the risk-based approach. The risk-based approach provides flexibility to obliged entities and supervisors as to how best to mitigate the risks of money laundering and terrorist financing. The focus on harmonization ensures that obliged entities interpret the law in the same way and supervisors adopt a standardized approach to supervision that is not fragmented on national lines. Harmonization is achieved by adopting a multi-level approach to the legislation in the package. At level 1, framework legislation establishes the broad base of the new rules. So, level 1 legislation specifies the powers of the Commission to adopt level 2 measures via delegated acts and implementing acts. The level 2 legislation gives detailed instruction for obliged entities, as well as harmonizing standards and practices relating to AML CFT supervision and the running of the BO beneficial ownership registers, among other areas. Finally, level 3 consists of non-binding guidelines and other measures to ensure consistent implementation of the single rulebook legislation. So now I'm going to focus on the protection of personal data in the AML package. The package has robust data protection mechanisms built into it by means of its reliance on level 2 and level 3 legislation to provide the details of compliance. So Regulation 2018-1725 requires the Commission to consult the European Data Protection Supervisor when preparing delegated or implementing acts that impact on the protection of individuals' rights and freedoms with regard to the processing of personal data. It further provides that where the delegated or implementing act is of particular importance in terms of its processing of personal data, the Commission may also consult the European Data Protection Board. The package provides not just for consultation, but also for the active involvement of the EDPS at an early stage in the preparation of the Level 2 instruments. The AMLA regulation states that where AMLA sees the involvement of the EDPS as adding value already at the stage of the Level 2 acts, it should inform the Commission and obtain its authorization to proceed with consultation with the EDPS. Therefore, in the development of the Level 2 instruments, there will be a direct involvement of the EDPS, with the potential also for the additional involvement of the EDPB in particularly sensitive cases. In such cases, the EDPS and EDPB shall coordinate their work with a view to issuing a joint opinion. For Level 3, the package contains a duty of consultation for AMLA with the EDPB, where guidelines or recommendations have a significant impact on the protection of personal data. AMLA shall closely cooperate with the EDPB to avoid duplication, inconsistencies, and legal uncertainties in the sphere of data protection. In addition, there is a mandatory duty for AMLA to consult with the EDPS after it has received authorization from the Commission to do so. AMLA may also invite national data protection authorities as observers in the process of drafting the Level 2 instruments. Level 3 instruments. So how does this work in practice? Well, we can see this in the Transfer of Funds Regulation recast, which has already entered into force and will apply from the end of this year. The Transfer of Funds recast obliges the CASP to accompany transfers of crypto assets with information on the originator and beneficiary. But there are obvious risks in such transfers of personal data, especially when the receiving CASP is located outside the EU. For this reason, the so-called TFR requires sending CASPs to assess the ability of the CASP of the beneficiary to receive and retain the personal data of the sender in compliance with the GDPR, using, where appropriate, the options in Chapter 5 of the GDPR. The TFR provides for the involvement of the EDPB to produce guidelines addressing the data protection risks involved in the transfers of personal data to CASPs that are not registered in the EU, and to work in cooperation with the European Banking Authority, which shall in turn issue guidelines on procedures for determining the appropriate treatment of a transfer of crypto assets in situations where compliance with data protection requirements for the transfer of personal data to third countries cannot be ensured. The purpose of AML legislation is to ensure transparency of financial transactions in order to prevent money laundering, its predicate offences, and terrorist financing. As such, transparency requires the processing of personal data involving the EDPS and EDPB, and where appropriate, national data protection authorities is an obvious safeguard to ensure that the requirements of AML do not disproportionately impact on the rights of data subjects. Involving the European data protection authorities in this way also reflects the recommendations of the international standard setter in AML, the Financial Action Task Force, which requires member countries to provide for cooperation between data protection and AML authorities to ensure the compatibility of AML CFT requirements with data protection and privacy rules. It also puts into practice the recommendations issued by the EDPB in its letter to the Commission of May 2021 on the Commission's action plan for the prevention of money laundering and terrorist financing, in which the EDPB called for cooperation between AML and CFT supervisory authorities on the one hand and data protection authorities on the other, to be laid down in the text of the AML package, specifically prior to adopting delegated acts, guidelines, or recommendations involving additional processing of personal data or affecting the right to data protection. Further protections of fundamental rights, including data protection, are provided by the requirement that AMLA and each member state's financial intelligence unit should have a fundamental rights officer. The role of the Fundamental Rights Officer is to monitor and promote compliance with fundamental rights by AMLA or the FIU. In both organizations, the Fundamental Rights Officer is to be independent in their functions and not to seek or take instructions regarding their tasks. They can issue non-binding opinions on the compliance by AMLA or the FIU with fundamental rights and report to the head of the FIU or in AMLA to the executive director. I will now focus on how the package deals with the Sovim case. In the Sovim judgment, the Court of Justice invalidated the requirement introduced by the 5th AML Directive that information on the beneficial ownership of legal entities held in central registers should be accessible in all cases to any member of the general public. It found that such public access was not strictly necessary to prevent money laundering or terrorist financing, nor proportionate, and could not justify a serious interference with fundamental rights, namely the right to respect for private life and protection of personal data in Articles 7 and 8 of the Charter. As a result, access to beneficial ownership of information of legal entities by the public is now conditional on the demonstration of legitimate interest. The challenge for the AML package is how to give effect to the Sovim judgment, not just for legal entities, but also for legal arrangements. The AML directive sets out the new AML directive sets out categories of legitimate interest as defined by the court in Sovim. These are press and civil society organizations connected with the prevention of money laundering or terrorist financing, persons likely to enter into transactions with legal entities or legal arrangements, third country obliged entities for CDD purposes, and third country counterparts of union, AML, CFT competent authorities. The package also provides for additional categories under the heading of legitimate interest, not mentioned in Sovim. These are union public authorities with an ancillary role in the prevention and fight against money laundering or terrorist financing. These are included to comply with FATF recommendations and other union acts which require a wide set of authorities than AML competent authorities to access beneficial ownership information. Prior to Sovim, these could rely on the public access provisions to access the registers, but now they have to be formally provided with access in order to carry out their functions. The final category under legitimate interest is the third country commercial AML, third party commercial AML providers, commonly known as watch lists. They provide a holistic view of the legal or natural person, which is useful for obliged entities, for CDD, and competent authorities for investigations. The package provides a safeguard in the requirement that such third-party AML providers must demonstrate that data from the BO register is offered only to obliged entities and competent authorities. The means of doing so is the requirement that they have a contract with the obliged entities or competent authorities. To ensure that categories of legitimate interest remain up to date, member states can extend access on this grounds on a case-by-case basis. They must notify the Commission of any extension of the categories of legitimate interest. To handle access under legitimate interest grounds, the registers must firstly verify that a legitimate interest exists and verify the identity of the applicants, including whenever they access the registers. The registers can refuse or revoke access, but have to provide for a mechanism allowing challenges to refusal or revocation. Registers must keep records of access under legitimate interest grounds and disclose them to the beneficial owners if they make data subject access requests. But the directive provides for limitations to the right for a data subject access request, where that access was by persons in the categories of press or journalism or civil society. In such cases, the register should ensure that their identity is not disclosed to the beneficial owner. Instead, data subjects receive information on the function or occupation of the person who consulted their beneficial ownership information. This is an attempt to reconcile the right to protection of personal data with freedom of information and expression for journalists in accordance with Article 85 of the GDPR, which provides for derogations from the rights of data subjects. Here it is important to consider that an access to information should not adversely affect the rights or freedoms of others, as stated in Recital 63 of the GDPR. Disclosure of the identity of a person accessing the register may lead to risks to the safety of journalists and members of civil society organizations who carry out investigations into potential criminal activities. For third country counterparts of AML CFT competent authorities, the registers will not disclose their identity for as long as necessary to protect the investigations of the authority, up to a period of 5 years, with the possibility of a limited renewal on request from the third country authorities. The extent of the information provided under legitimate interest grounds depends on the category that the person requesting access falls into, with additional categories of information provided to journalists and civil society organizations and third country competent authorities. The introduction of access to the beneficial ownership registers based on legitimate interest requires Level 2 acts to ensure harmonization across the member states. This takes the form of implementing acts in a number of areas, permitting the Commission to set out standardized templates to request access to the beneficial ownership register and access to beneficial ownership information on legal entities and legal arrangements. Standardized templates to be used by the registers to confirm or refuse a request for access to the register or to access beneficial ownership information. Procedures to facilitate the mutual recognition of legitimate interest by the central registers in member states other than the ones where the request for access was first accepted, and procedures for central registers to notify each other of revocations of access. The current AML directive allows member states to provide for exemptions from access to beneficial ownership information by the public of legal entities where, in exceptional circumstances, that access would expose the beneficial owner to a disproportionate risk of interference with their fundamental rights. The new AML directive provides enhanced safeguards for the data subject by changing that option into an obligation to grant such exemptions to requests for beneficial ownership information on the grounds of legitimate interest and for customer due diligence purposes on the same exceptional circumstances basis. The directive provides strong powers to the registers to ensure the accuracy of the beneficial ownership information which they hold. They have the power to request information and documents, carry out on-site inspections, and impose sanctions for failure to provide the register with accurate, adequate, and up-to-date information on the beneficial owner. The registers must check the accuracy of the beneficial ownership information on first registration and at intervals thereafter. They can withhold or refuse a valid certificate of proof of registration or suspend the validity of proof of registration if there are errors or inconsistencies in the information provided. They have a duty to resolve discrepancies in beneficial ownership information provided to them by obliged entities or competent authorities. They must have policies to prevent and manage conflicts of interest. They also have a duty to report to the FIU facts that are linked to money laundering or terrorist financing. Finally, and very briefly, as the partnerships for information sharing will be discussed in detail later in this panel, just a brief word about the protection of fundamental rights provided by the package in this area. The partnerships for information sharing, as set out in the Council's general approach, were the subject of concerns expressed by the EDPB. As a result, the co-legislators have ensured that there are robust protections for fundamental rights built into these partnerships. They include, prior to the start of the partnership, the obligation to carry out a data protection impact assessment and the obligation to inform AML supervisory authorities of the establishment of the partnerships. The AML supervisory authorities will check to determine compliance by the partnerships with the requirement of the regulation, including that the data protection impact assessment has been carried out. The partnerships must use technical and organizational measures, including pseudonymization, to ensure the security and confidentiality of the information exchanged. There are also provisions to prevent de-risking. This has been a very rapid overview of a very large subject. The key takeaway is that the AML legislation's focus on harmonization and its resulting reliance on Level 2 and Level 3 legal instruments to fill out the details of compliance means the direct involvement of the EDPS and EDPB in legislative development in areas where the processing of personal data is concerned. This means that strengthened AML procedures will be balanced by strong protections of personal data. Thank you for your attention.
Thank you, Anne. And as we can see, central to AML package is consideration about personal data safeguarding, and it's very good. I hope we will speak one language soon with AML and data protection people, and we can understand each other. I lead to our next speaker, who is Dr. Michelle Fresher. She is independent consultant and faculty to the EU Global AML CFT facility. Dr. Michelle Fresher is an academic turned practitioner, and she brings over 20 years subject matter expertise in geopolitics, finance, terrorism, illicit flows, and data privacy, with experience in leading multidisciplinary teams to build AML, CFT, and sanction compliance products and services for a global clientele. In her corporate career, Fresher served in key leadership positions at Nexus Risk Solution as Director of Global Content for World Compliance. As I mentioned, our today's speakers are very impressive experts in their fields, and Dr. Fresher will tell us about areas where AML and GDPR objectives align and where they diverge. Please, Dr. Fresher, floor is yours.
Thank you so much, and so thank you also to Latvia, our hosts, for putting such a fantastic program together, and also for their invitation to talk about my absolute favorite subject, which is the intersection of AML and data protection. So you can see from my title is Better Together. So I really feel that there are mutual interests with both of these groups. The fourth anti-money laundering directive was the first anti-financial crime legislation to include data protection. And as AML uses a lot of data points to assess whether a person may be engaging in criminal activity, data protection is really a natural extension of the exercise. Although they might have different motivations, AML and data protection do have mutual interests. They both want adequate, relevant, and accurate data. So using the right data to arrive at the right results, and that's really foundational to both of them. For anti-money laundering, bad data underpins bad decisions, right? And those bad decisions, those bad results waste resources They produce false positives that are timely and costly to clear. And remember that banks, financial institutions are in the business of making money. So the more money that they're spending on things that aren't working well, things that aren't efficient, really aren't in their interests. So having the best data to get to the best results is very important. In turn, officials may receive incomplete or inaccurate reports in volumes that their resources cannot possibly sift through, which means that they're going to miss really pivotal clues as well. On the other side, for data privacy and protection, looking at bad data, bad results raises the possibility of individuals losing benefits and access to the financial system through de-risking. And individuals being reported to authorities that are acting legitimately. Client blacklisting, biased results, especially in the new use of AI tools, is a concern, and all of this impinging on human rights. It's nearly a decade later since 4 AMLD, and now we have a new AML regulation and a new authority that expands this role for data protection. And so now is the time that we really have to put these two groups together and get some good guidance to bringing them into an operational reality. So it's little surprise that Working Party 29's 4 AMLD observations have resurfaced with the EDPB and EDPS assessments. So today, I'm going to address two specific areas, looking at proportionality and the risk-based approach, and then also that gives rise to looking at the data in the workflow. So obliged entities or obligated entities screen and review every step of the business relationship. So onboarding, ID verification, transaction monitoring, payments, investigations, and to assess if an individual's actions might indicate that they're engaged in illicit activity. And every obliged entity's risk model is tailored to their client base, their product and services, their geography, regulation, national risk considerations, crime topologies, and so on. These risk decisions involve data from multiple sources: the client, private data providers, government databases, advice from FIUs, regulators, law enforcement, and of course their own internal data assessments from transaction screening and monitoring. So the chart behind me is just looking at a very simple data flow, and I know it doesn't look simple, but this can be much more complicated, obviously depending on the type of product, the financial institution. But what you see here is a lot of data being analyzed and decisions coming from it. And then I have this little triangle in the corner there with AI, and we have AI being layered on top of these decisions to get to better results, to help humans discern whether or not something illicit is happening here. So as you can see, there's a lot involved. The volume of information challenges the principle of proportionality, but processing on this scale cannot be avoided due to the nature of finance. Millions of customers, trillions of transactions a day requires these large volumes. And since finance is data, it really is connected. However, what we can do is focus on improving the data that supports the risk models, so we're getting better risk models for better targeted results to locate illicit actors and having less impact on individuals. So the promise of a single rule book at the EU level is really an advantage here. And data protection is an absolute essential and valuable tool to help AML data to set best practices, to improve AML effectiveness, and also protect the rights of individuals. And the AMLR annexes outline preliminary risk variables and factors with regulatory technical standards, and this is the way forward. These will serve as the foundations for improved risk models, and AMLA will develop these in the next 2 to 3 years. And so a lot of that is really reflected in the recommendations that we have seen on both sides of the fence. So Working Party 29 and also the EDPB, both focused obviously on the data level, requested guidelines on AML data elements, those variables at each stage of the process with clear and transparent criteria for these escalations and trigger events that necessitate reporting. So working with the RTS, you also have the same views reflected in the Financial Action Task Force, the international governmental body that sets AML standards and recommendations, that publish guidance saying that governments should look at the standardization of data elements for risk assessments to standardize the data in a way to promote interoperability so we're all speaking with similar voices. They also said, has been noted already, that the goals of AML and data protection are not mutually exclusive. So even FATF is saying, look, there's tremendous benefits to using these tools. So the good news here is that the AML community has already been engaged in these types of efforts and has several projects underway to establish these minimum operational data points and to use industry data standards already in place using ISO and through payments and other payments data and other standards. So we don't have to reinvent the wheel because finance is already thinking about this ahead. And there are lots of benefits to doing this, so I've just listed some to go through. This way, the EU can work together and use some of these standards and these efforts already in place and produce a catalog of data classifications and RTS guidance to create a common language. And doing that, then you create core but adaptable data variables that are more targeted for effective risk assessments. And then this is an ongoing, this isn't a one and done practice, this is ongoing, it has to be tooled, and that means that this is an opportunity for continued and closer consultation and collaboration between AML and data protection leaders, but must also include the financial services in the complete ecosystem of players in the AML and the financial world, because there's a lot of groups that are contributing to the success of AML compliance. And building these core risk variables means considering core privacy principles like data minimalization, transparency, accuracy. But in fact, the AML authorities are already doing this without even realizing this. And this is where sometimes different vernaculars can get crossed in the cooperation, because these are foundational to good data methodologies. You're going to look for the right data to get to your target. You're not going to use extraneous data variables when you're tweaking models. So finding the right data to get to the right results. So focusing on data means focusing on the data that's used in the workflow. And so we can look at two areas that cross over here, which is the purpose limitation for commingled data sets and data quality frameworks for obliged entities and the private data providers that have already been mentioned. So obliged entities and authorities use intermingled data sets, which can challenge purpose limitation, as some of the data has been collected for purposes other than AML. However, these interwoven data sets are really extremely useful, and they're used to validate AML data sets that perhaps we don't have as much confidence in terms of the data quality. They can align data across formats, languages, jurisdictions, And they're also helpful to make linkages between data sets and processes to detect illegitimate networks and discern them from people using these products for legitimate reasons. And so that's a very helpful analytical tool. And also to comply with other legal obligations such as fraud and sanctions. So for example, a beneficial ownership database is absolutely pivotal if you have a economic sanctions screening list. You can look down the ownership chain, say a business is saying, what does my supply chain involve? And I can say, oh, well, I see 2-3 levels down. This is actually linked to someone on a restricted entity list, and I really should proceed with caution, ask other questions. You wouldn't be able to get that with just a straight screening on a sanctions list. So data providers, these private data providers, specialize in collecting and collating and quality checking data with various methods, including trained research teams, so having humans telling them what to look for and reading this data for inclusion, or machine learning or other technical methods. And they gather data from multiple sources: financial disclosures, open source media, published regulatory lists, government databases, and so on. And for every obliged entity or authority to do this on their own, it would be impossible. It would be too costly and too expensive to do so. So without this service, others could not actually do their legally mandated due diligence. To accommodate these purpose limitations, vendors may narrowly define the use cases of their database, and they may collect data only for a specific purpose and then sell that to people to use it just for a specific purpose. Or in the case of commingled data sets, they will structure their contracts to leave the legal permissible use to their clients. So they'll sell the database, and it's up to the clients to make sure that they're using it for the legal means. Data providers are, as you know, obligated under GDPR, so they do have to pay attention to those provisions. But they are not considered obliged entities under the 4th Anti-Money Laundering Directive. And as such, so what happens is that they typically cite the legal basis for data collection through their clients' obligations and their legal mandated duties through GDPR Article 6 exceptions, right? So member state law or public good. The new AMLR considers data providers part of the obliged entity through their contracts with them, again, placing responsibility for data quality with the obliged entity. So data quality always ultimately lies on the client, in this case, the obliged entity. But these gaps expose these data vendors to litigation. They put obliged entities at risk. And in some cases, they have failed to protect individuals from the negative consequences of some poor industry practices. So law firms will typically write to these data vendors and cite GDPR as grounds for removal for their clients from these databases, and an effort sometimes to hide misdeeds. Maybe they've been in an indictment in other countries, and they will also ask for removal of PEP roles that haven't been explicitly defined in legislation, so they can't be screened. And so the vendors really are faced with a choice. They must decide whether to keep them and face potentially costly litigation, or delete them and pass that risk to their clients, saying if it's not in the database, you can't screen on something that's not there. And then ultimately, obviously, that has effects on society and the overall effectiveness of AML and trying to get to these illicit actors that are harming society in numerous ways. Lastly, individuals who are not high risk, who have been falsely included in these databases, also have risks, and because they're maybe of denied service or other negative consequences. So the EDPB has recognized the importance of data providers and these issues and did ask for specific legal frameworks to clarify their responsibilities under GDPR, especially regarding Article 9 and Article 10, sensitive data and criminal convictions, because there's a lot of ambiguity there, and called for certification standards. This did not materialize in the regulation, but my point is here that we need, regardless of where this data comes from in this mass ecosystem, we really do need to address all of the players that are contributing to the success here and form data quality frameworks and establish for all of them. So the way forward, I've given a lot of suggestions here, and really what I'm saying is that there's an opportunity here for DPAs and financial crime practitioners alike to cooperate. And I've spoken and worked on both sides of this fence, and what's commonly said is there's no forums for us to get together and really have a knowledge exchange and learn from each other. And that is what we really need to do and prioritize. We can't discover common interests and work through our common challenges if we aren't engaging in that dialogue. And so the EU authorities' mandate provides an excellent opportunity for a multidisciplinary working groups. So lastly, I'd say that I'm optimistic that we have entered a new era of leadership that will promote greater cooperation between these groups. Thank you very much.
Thank you, Michelle. It was very interesting and point of view. I fully align with your opinions that one rule book guidelines are essential to ensure compliance and common understanding. Thank you very much one more time. And we proceed to our next expert, Mr. Nick J. Maxwell, Head of the Future of Financial Intelligence Sharing Program, hosted within the Royal United Service Institute Center for Financial Crime and Security Studies. Yes, prior to this role, Nick's professional career has included Head of Research and Advocacy for Transparency International UK, providing anti-money laundering specialist advice to NATO, and he has many more other prominent positions. Yes, please take the floor, and we are looking forward for your presentation, The Future of AML Collaboration and the Smarter, Smaller Data Collection Burden on Society.
Thank you very much, and it's a pleasure and an honor to be part of the conference today, and I really applaud the data protection community, the Latvian Data State Inspectorate, and the organizers of the Spring Conference, really in this leadership about bringing together the AML issues, which are very dynamic right now. It's a period of change in AML regulation around the world, and the crucial importance of data protection and fundamental rights. It's an area which has been neglected in previous decades, and I think now we're seeing that leadership to bring together considerations on both sides. So I'm really delighted to be here, and it's of crucial importance. So I'm going to talk about the future of AML collaboration from an international perspective and zero in on the EU changes with regards to AML collaboration. I'll touch on public to private sector, public-private partnerships, but principally I'll be referring to private collaboration. They have different characteristics, but there's, of course, an intersection between them. So I'm Nick Maxwell. I head the Future of Financial Intelligence Sharing Research initiative within RUSI, which is the Royal United Services Institute, Center for Finance and Security, so quite a mouthful there. If you think the kind of data protection world is bad for acronyms, you should really try the AML world. We have lots of acronyms, tremendous amount of acronyms. So the FFIS program for short. Since 2017, we've published 7 major international comparative studies, really looking at the different ways in which country practice is evolving with regards to information sharing issues and the AML regime. We have looked at public-private partnerships and surveys of different operational public-private partnerships, the legislative environment to support those public-private partnerships, technology issues, governance issues, supervisory issues. We had a specialist project on privacy-enhancing technology and the role that pets may play with regards to information sharing issues and data protection compliance in the AML space. And perhaps most recently, we've really focused in on private-to-private collaboration, publishing the largest survey of fraud prevention and AML private-private collaboration platforms. And that work was relevant and timely for the FATF when they were considering their advisory guidance partnering in the fight against financial crime. And most recently, we've published just in January a series of papers on the payment system. The payments world is another bubble which is very relevant to financial crime threats and also undergoing tremendous reforms as it moves towards faster payments cross-border and also the push towards digital currencies. Again, I would say in the future we need to consider that bubble alongside the data protection bubble and the financial crime and fraud bubble. Let's burst these bubbles. That might be a message. So I think the logic behind a collaborative analytical approach towards identifying the threats in a financial crime and fraud context is relatively obvious. When the FATF regime was established, that's the international standards regime for AML, it was the tail end of the 80s, early 90s, and there was a lot of paper-based banking, and banking relationships were managed by humans in a personal relationship very often. And so that world is a different dimension to where we are now in digital services, digital financial services, digital economy, an era of tremendous data when it comes to financial services, but also when we're thinking about the nature of the crime, it's crossing multiple obliged entities, and indeed it's crossing borders. So individual obliged entities have a tremendously limited view of the risk that they are meant to discover. And the risk is, of course, spread across multiple obliged entities and across sectors. So the opportunity to be more effective requires a collaborative analytical approach across multiple obliged entities. It's important to note that I think because of that legacy of a 1980s, 1990s regulatory system, there have been huge challenges with the AML-CFT system, many of which are data protection challenges, and we've talked about perhaps the tension in AML-CFT systems with regards to justifying proportionality. Essentially, when it was designed, it was a data maximalist framework, where the idea was that each individual obliged entity, of which there are tens of thousands in most countries and hundreds of thousands in some countries, should absorb as much data as possible about risk to better identify risk within their individual silo of their customer behavior. And of course, this is very difficult to justify, really, in today's world on effectiveness grounds, because individual siloed entities have a very limited view of the behavior, the target behavior, and this huge hoovering up and duplicative processes for the data that's required for those assessments presents a data protection challenge. So limited visibility. We've had over-reporting because in the past, AML supervisors have put pressure on regulated entities to improve their reporting, and there has been an incentive for reporting through to financial intelligence units and no incentive or disincentive for reporting too much. So there's been a regulatory pressure for over-reporting through to FIUs. It's been very high numbers of false positives looking historically at individual regulated entities systems, and also the amount of data throwing through to financial intelligence units. And historically, there's been a lack of public-private and private-private collaboration. What that means is that all these regulated entities have been just working by themselves with very poor risk indicators, sometimes entire geographies are used as a risk indicator in the past, and not able to benefit from a more precise, intelligence-led understanding of risk that is drawn from particularly public-private collaboration. There's also been a lack of clarity around financial exclusion issues. I think that's still something that requires further dialogue between policymakers about whether the purpose of the system is to actually exclude some entities related to their financial crime risk in a particular context, in a particular country, in a particular jurisdiction, or not. There is a tension, and perhaps we see that most evolved in the European Union, about the right to financial services against the tendency of the AML-CFT regime to exclude and lead to exit decisions. So there are still policy decisions that really do require deconfliction in this system. So now I'm going to talk about partnerships and how they have contributed to alleviating some of those challenges and improving principally effectiveness issues, but more and more we are seeing a contribution to data proportionality gains as well. We've surveyed public-private partnerships around the world. Just from a 2020 survey, this map illustrates the public-private partnerships as they had developed at that time. And there was really a tremendous growth from 2015, where there was really no public-private partnerships in the AML space, to 2020, which this map records a snapshot of. So it's been a real period of innovation with regards to public-private partnership, and that has been driven by the more effective results that these partnerships have been able to demonstrate when it comes to understanding risk, when it comes to supporting investigations, asset recovery, arrests, when there is collaboration at the public-private partnership level. We ourselves, as a think tank, so all of our work we publish to make publicly available, but we host a lot of events, a lot of discussion activity, both as contributing to the research process, but also in the communication of our research afterwards, but more so to allow leaders to get together from public-private sectors and from a multidisciplinary approach to consider latest practice, latest understanding of challenges, and to provide a space for reflection about the effectiveness and efficiency and data proportionality of the systems that we currently have. And there's lots of room for improvement. There's lots of appetite from leaders, policymakers, as well as in supervisors and in industry to address these issues. And that's perhaps why we've seen some of the reforms over the last few years. There are a lot of public-private partnerships that were represented at our Conference of Partnerships. Again, a sea of acronyms. The partnerships do love their acronyms. My favorite perhaps is the Irish Joint Intelligence Group, the Irish JIG is a good one. Various other acronyms floating around. In terms of the impact of these partnerships, we're able to demonstrate a much more clear link to quality gains when it comes to the value of the reporting coming through from entities when it's related to a public-private partnership. So historically, the AML-CFT system had a really hard job, actually, demonstrating value, because there was such a big gap between what regulated entities reported through to FIUs, what FIUs reported through to investigators, what investigators used for a case, and when a case came to completion. So it really struggled to have good data on what effectiveness was. But actually, public-private partnerships have provided us with more granularity on these questions. So the partnerships in the Netherlands have contributed to a 6 times or even a near 10 times increase in the quality of the reporting. So that's when the FIU has determined that the reporting coming through from the private sector is of high quality enough to disclose on to law enforcement. They have a gatekeeper role for the quality of the intelligence. We've also seen that partnerships are able to stimulate reporting from the private sector. The previous model was that the private sector just had to do their best, and then the FIU worked with whatever came through. But actually now we're seeing when there's a specific focus on a threat in a country, and there's a feeling that there's an underreporting from the private sector, this can be addressed through public-private partnerships. So we saw a 20-fold increase in trade-based money laundering reporting because of a public-private partnership focus on that threat. In Australia, there was a 580% increase in reporting on a child exploitation threat because there was a focus on that issue. So we can stimulate reporting through public-private partnerships and make it much more intelligence-directed. You can see here how that looks in terms of a quantitative view of the increase in reporting. This is in Australia. The public-private partnership was able to tag the reports that were coming through related to a project on child exploitation, and there was a huge increase following the public-private partnership work. Another tracking of SMRs, they call them suspicious matter reports in Australia. These are the reports coming through from industry to the Financial Intelligence Unit. And even the initiation of a public-private partnership, not just the publication of the end results, was leading to a stimulation of reporting through from industry. So these public-private partnerships have really enhanced and improved the responsiveness of the AML-CFT system to shared national threats. The European Commission published guidance on PPPs in 2022. Has a lot of detail on guidance for national decision makers, particularly on data protection issues, but also on competition law issues, as well as AML-CFT issues. Private-to-private collaboration then. The FATF published advisory guidance in 2022, which recommended that countries consider enhancing private-private sharing. There was also recommendations there relating to how data protection issues should be considered, and also engagement with technology, particularly privacy-enhancing technology. Our survey, I'll just run through this very quickly. So we looked at fraud and AML. There's a big intersection when it comes to the actual threat, but typically collaboration partnerships work within a legal regime that is either focused on the fraud legality for information sharing under a fraud prevention purpose, or in an anti-money laundering space. There is an overlap, of course, and GDPR itself is an enabling legal framework for fraud prevention information sharing due to the specific reference in the recitals, but we haven't seen in Europe the same level of clarity about money laundering private-to-private information sharing until now. So there's a big change. There's different types of private-private sharing, so I think we should, data protection authorities will need to get into the detail of this, because different types of interactions require different data and produce different results and have different risks. In the new EU AMLR Article 75, there's an implicit requirement of data protection authorities to help advise on the partnerships adherence to the conditions in Article 75 supporting the AML supervisor in a verification process that happens prior to the partnership being sharing information, so at the design stage, really. So this is a new duty that's implicit in the AML regulation for data protection authorities, and it's where our research will really focus. So we chart all the kind of benefits of collaborative analytics, and there's a lot of quantitative as well as qualitative data there. It's all available in our research, which is publicly available. I just want to highlight this benefit of collaboration when it comes to being more precise. The data from the US, which has the longest standing legal framework for AML information sharing back from 2001, and the most mature environment for private-to-private sharing, is showing, ironically in a way, it has the, a lesser developed privacy regime compared to the EU, but despite that, there's not the same pressure to consider the GDPR issues, obviously in the US, but despite that, the collaborations through the US legal framework are demonstrating the ability to reduce false positives and reduce the filing of activity through to the government FIU. We examined private sector data and showing that in 56,000 cases of private-to-private collaboration over a certain time period, 60% through the act of collaboration were able to be explained, or there was sufficient explanation from a counterparty to close the case as non-suspicious. Without the collaboration, there would be an uncertainty and there would be a regulatory risk if that regulated entity didn't file the report through to the FIU. So that's just a huge amount of data on effectively innocent behavior, which with in the absence of collaboration, is being filed to the state and being used by the Financial Intelligence Unit. So there's a really important effectiveness, efficiency, and data proportionality case to help improve these systems through collaboration. So I'll stop there, and happy to go into more detail later on in discussion.
Thank you, Nick. Yes, collaboration is the main word in all this story. Now, I want to present our next panelist, and next speaker is Mr. Andris Stangrevits. And Andris Stangrevits is a lawyer and privacy protection expert, CIPPE, with experience of more than 10 years as certified data protection officer, from which 7 years are working in banking industry. Andris is currently holding the position of privacy protection manager and DPO in Citadel Group, as well as the position of chairman of GDPR working group of Latvia Finance Association. Good morning, Andris, one more time, and the floor is yours.
Good morning, ladies and gentlemen, and dear speakers, moderator. Today I will present you a theme on possible developments in AML and GDPR interplay field that we may experience in the very close future due to new financial regulations. As I'm a privacy protection expert, and after all, this conference is dedicated to privacy protection, I'm begging in advance your pardon for analyzing the given theme from perspective of privacy enthusiast, not AML expert. So if we're looking back, so to predict something, we must look back at least to understand where do we come from. So if we're looking back to EU legislation, then we can see that only starting from 2015, which is the fourth AML directive, legislator has come up with a dedicated approach in respect to personal data processing aspects. In recital 43 of the fourth AML directive, we witnessed the importance of privacy rights being pointed out, stipulating that personal data processing for AML purposes shall be performed fully respecting fundamental rights. At the same time, the fourth AML directive recognizes public interest as the ground for processing of personal data. In national legislation, there were several breaking points, which I see as the moments when privacy protection rights are recognized as the core element of AML CFT regulation system, not just supplement, but the core element. The first breaking point are amendments to national AML law in 2017, when law was supplemented with several personal data processing principles, which we today know as purpose limitation principle. Amendment stated that data collected shall be processed only for purposes of AML law, and commercial usage of data was prohibited. Accuracy principle. Amendment stated that obliged entities were responsible for regular assessments and updating of documents, information, and personal data. Storage limitation principle. Amendments provided stricter requirements towards retention periods, which were limited to 5 years in total, except for the requests of authorities. The next breakthrough in national legislation was in 2019, when national AML law was amended with provisions that stated public interest as a ground for processing of personal data, and in 2021, when the regular privacy protection trainings were added as mandatory to other core trainings AML personnel needs to pass to perform their duties. From review I just presented you, we do see that AML GDPR relations are not only coexisting, they are evolving together. Further on, I want to present key takeaways from my vision of AML regulation. And they are: regulation shall be applied respecting fundamental rights and observing the principles recognized by EU Charter of Fundamental Rights. The processing for the purpose of fight against money laundering and terrorism financing remains prioritized on grounds of an important public interest. Purpose limitation principle remains in its place and as it was set by the fourth AML directive. Record retention and personal data processing policies shall be in place with obliged entities. Awareness of AML personnel on data processing policies is mandatory obligation for obliged entities. An automated individual decision-making, including profiling, as set under Article 22 of GDPR is allowed. Yet again, the disposition of legal norm says that legal entities may adopt such types of processing. Thus uncertainty regarding applicable legal grounds for such processing remains. Specific provisions of processing of GDPR Article 9 and 10 data are enshrined in AML regulation, providing the legal ground for processing of special categories of data. Presumably it's point G, Article 9 of the GDPR. At the same time, the legislators are proposed to point out that sole processing of special categories of personal data shall not lead to preclusive intervention in business relationship with customers, where such information bears no relevance to risks associated with money laundering and terrorism financing. In addition, the safeguard for processing of GDPR Article 10 data shall be procedures that allow the distinction in processing of such data between allegations, investigation, proceedings and convictions, taking into account the fundamental rights to fair trial, rights to defense, and the presumption of innocence. So the storage limitation period 5 + 5 years remains unchanged. In addition, providing ground for setting longer retention periods to comply with national regulations. P2P data sharing framework must adhere fundamental rights and implement DPIA assessments. In draft document, it is said that P2P data sharing may result in a high risk to rights and freedoms of natural persons. Therefore, DPIA assessments shall be carried out and supervisory checks provided. Authorities may participate in this private partnership on basis of law enforcement directive. And the last but not least, the restrictions in application of data subjects' rights shall be justified in accordance with Article 23 of the GDPR. When such restrictions apply, DPAs may exercise their supervisory rights. Further on, if we do talk about predictions, if we do talk about predictions about future of AML GDPR interplay, I must admit the challenges we face are the ones creating the future landscape. Due to the reason that already now obliged entities are using sophisticated tool in AML risk scoring, transactions monitoring, change monitoring, sanctions screening, remote identification by means of processing of biometric data, data mining techniques, the future landscape seems to remain complex, full of different technical breakthroughs and hard to predict, even despite this new set of proposed legislation. Most of these tools, if not all, are performing profiling or are designated to perform their tasks in connection with other IT solutions that contribute to profiling and automated processing, including decision making. One thing I can say for sure is that the future is all about the proper and timely governance of AML processes and efficient, effective control measures. It is clear by now that such phenomena as gold plating of AML, CFT obligations, or evergreen data retention schemes, or excessive data processing will remain on privacy experts' task list for a while. You may ask why. The privacy protection rights are just making the first steps in this highly regulated, coherent, complex and constraining framework of AML regulations, which to a certain extent and without proper controls in place is quite hostile environment for some civil liberties. This highly regulated framework is not frozen in a moment. Actually, it is volatile and rapidly evolving due to merging of new advanced technologies and methods. For instance, usage of artificial intelligence in data mining and profiling, expansion of almost borderless data sharing privileges in private partnerships. Thus, privacy experts and DPAs must be ready to ask uncomfortable questions on the necessity, application, and operating limits of some technologies and methods, bearing in mind that phenomena I just mentioned tend to exist and influence processing of personal data in AML CFT environment. Then, privacy teams of obliged entities face the distinct challenge of choosing proper legal basis for processing. Here, the approach may largely differ from member state to member state. Not all national laws contain detailed provisions on means of processing, types of data to be collected, and safeguards to be implemented. To interpret requirements of law as the legal obligation binding to obliged entity. Most legal norms included in AML CFT laws have general rims. For instance, reference to obliged entities, risk governance methodology, rights to implement certain actions, not obligations to do so. So the privacy experts are aware that the legal obligation as a ground for processing requires minimum effort in terms of accountability. On contrary, if the basis for processing are legitimate interests or public interests, the burden of accountability remains with the controller, inter alia with respect to privacy impact assessments and private persons' rights to object to processing, if the latter rights are not restrained under Article 23 of the GDPR. Members of our working group in Finance Latvia Association recently approached our DPIA asking to elaborate possible outcome of the situation when two obliged entities would have applied two different legal grounds for processing of personal data in the same situation, in the same manner, applying the same legal norms. So we asked, is it possible that those two alternatives may coexist, facing the decision of DPIA? The answer was no. One legal ground would remain as fit and proper, the other one not. So the correct choice of legal grounds will be an exhausting challenge of obliged entities' privacy teams. And so I come to the last predictable challenge I'm willing to emphasize, the privacy impact assessments. I will not deep dive into discussion of role of legislators in provision of compelling privacy impact assessments in legislative process, as it is enshrined by Article 3510 of the GDPR. Such assessments are often not persuasive due to their formal nature. Instead, I'm rather willing to point out the necessity of private impact assessments as a control mechanism that may help to avoid conventional hazards to privacy rights I mentioned previously and achieve balance in applying AML CFT laws and privacy protection obligations. As it was outlined by Article 29 Working Party in 2011's opinion on data protection issues related to prevention of money laundering and terrorism financing, privacy impact assessments must provide balanced guidance for obliged entities by carefully defining the exact scope and the necessity of AML CFT tasks and obligations. If I may, here I foresee one major problem in performing of such assessments: how to achieve unified approach in performing them. For instance, the same P2P data sharing platform. We may have there jointly participating from tens to hundreds of obliged entities. Does every obliged entity need to provide its separate DPIA? So can DPIA authorities rely on the decent outcome of such numerous DPIAs? Will DPIAs be an effective tool to safeguard the interests of private individuals, as DPIA methodologies will differ from one controller to another? Will multiple DPIAs on one solution start the decline in importance and quality of this privacy impact assessment tool? Maybe the proper answer is in consolidating the efforts of controllers under one approach that allows to perform DPIAs in unified manner. One DPIA for the whole solution and for all participants. If the latter scenario will exceed others, we surely will see the increased participation of associations and other bodies representing categories of controllers in processes related to privacy impact assessments. We will succeed if we act together. Dear audience, thank you for your attention.
Thank you very much, Andris. Yes, I can see that a lot of challenges we will have, still have. Okay. Yes, and about these challenges, about maybe another things, I would ask maybe we have any questions from the audience, because now we can proceed to this discussion part. And I can't see any for now. Okay. Then I have prepared some questions for our distinguished experts. Yes, and first of all, I would like to ask Anne. Anne, are you here? Are you with us? Okay.
Hopefully you can hear me.
Yes, we can. We can't see for now, but I hope it will change soon. Okay, but Anne, in the context of an AML package with increased and more explicit obligation for obliged entities, is there not a risk of an unintended consequences that financial institutions may resort to the risking, and what, if any, measures does the package have to reduce the incidence of the risking?
Well, de-risking has been recognized as a problem in AML for a number of years. De-risking can weaken the AML framework and the detection of suspicious transactions as they push affected customers to resort to less secure or unregulated payment channels to meet their financial needs. At the same time, widespread de-risking practices in the banking sector could lead to financial exclusion for certain categories of payment entities or customers. So the AML package provides a number of measures designed to prevent unjustified de-risking by financial institutions. Firstly, the AML directive provides for cooperation between AML supervisors responsible for financial and credit institutions with other supervisory authorities who are competent for supervising credit institutions under the Directive 2014-92, which deals with access to payment accounts with basic features, and Directive 2015-2366 on payment services in the internal market. The purpose of this cooperation is to reduce de-risking. So AML supervisors can identify situations where a credit institution has refused to enter into a business relationship despite being obliged to do so under these directives and without a justification based on documented customer due diligence. So AML supervisors should alert the authorities responsible for ensuring compliance by financial institutions with these directives when such cases arise or where business relationships are terminated as a result of de-risking practices. In addition, the AML regulation requires obliged entities when undertaking CDD to keep record of the actions undertaken and the information obtained during CDD, irrespective of whether a new business relationship is established with the customer. When the obliged entity takes a decision not to enter into a business relationship with a customer or to terminate an existing business relationship, it should include a justification for the grounds for such a decision. This will enable supervisors to see if they are appropriately applying a risk-based approach to such decisions or are engaged in de-risking. As a further safeguard, AMLA should issue joint guidelines with the EBA on the measures that may be taken by credit institutions and financial institutions to ensure compliance with AML CFT rules when implementing the requirements of Directive 2014 on access to payment accounts with basic features, including in relation to business relationships that are most affected by de-risking practices.
Thank you, Anne. And Nick, would you like to comment?
Yes, thank you very much. So the new kind of legislative wave that's kind of manifesting itself in jurisdictions all around the world on private-to-private sharing This is still, I think, an ongoing challenge. It's why I reference financial exclusion at the outset. In the EU, the private-to-private information sharing article within the AML regulation is Article 75. It will come across data protection authorities' desks because within Section 2, Paragraph 2 of Article 75, there is a role for AML supervisors to verify whether the partnerships have met the conditions within Article 75. Most of those conditions are data protection conditions, and one of those relates specifically to protections against financial exclusion issues. So data protection authorities will have to engage in advising the AML supervisor on whether the partnership proposal meets these conditions or not. So it's something that's going to be really important for data protection authorities to have the expertise, to have the people, to have the cooperation mechanisms with AML supervisors to do this. On the specific issue of financial exclusion, a broader theme that we're seeing is the evolution from the previous AML CFT norm, which was that regulated entities would just de-risk once it gets to a certain level of risk, and in fact that was encouraged by AML supervisors. We're now seeing AML supervisors recognize this tension with a right to financial services, and we're seeing the push towards limited service accounts. So if there's a high-risk entity for money laundering, that there wouldn't be denial of financial services unless they're a sanctioned entity, but for denial for high-risk entities there would be more limited service accounts to limit the opportunity for money laundering and actually enhance the opportunity for data to support an investigator through the reporting process. There's a lot of good examples here. I know we have colleagues from Denmark, and Denmark are doing some thinking in this space to lead the way, but data protection authority engagement will be really crucial.
Yeah, thank you. But Nick, don't put your micro down, because if you started this topic, I would ask you your opinion. How can AML supervisors and DPIA authorities best work together to the topic of AML Article 75 partnership?
Yeah, this has been a tension in the AML CFT system for a long time. If you go to an AML conference, there'll be a lot of, in the past, there would have been a lot of frustration, I suppose, about their ability to fulfill AML obligations whilst also meeting the expectations from a data protection authority perspective, and a feeling that the two were not speaking to each other. The supervisory regimes were not speaking to each other, and it was just which supervisor had the biggest stick was the kind of conclusion that the obliged entities had to rely on. But now I think we're seeing a more mature dialogue between data protection authorities and AML supervisors in particular about balance. And as we've said, I think all the presentations have referred to, this is a system where it is possible to be more effective, to be more efficient, and to have a lower data intrusion in society. That's probably a testament to how bad the system was designed back in the 90s, or how unfit it is for the digital era. But there is a big opportunity here, and the EU will lead the way, because Article 75 requires this dialogue between data protection authorities and AML supervisors at the partnership design stage. The problem, and I think I got the feeling from speaking to a number of data protection authorities, is resources. So most data protection authorities are very constrained in their resources. They don't necessarily have someone who is an expert in AML issues, perhaps not well placed at the moment to engage in these verification processes and these dialogue processes with the AML supervisors. That needs to change somehow. But recognizing those resource constraints. From our work, we'll be doing a research project on Article 75 implementation across the EU. We're running workshops all across the EU. We invite engagement from data protection authorities, and hopefully that is an opportunity to support the dialogue, but also to get ready for thinking about how are these conditions in Article 75 going to be assessed, because you're going to have to provide advice on whether the partnerships are meeting the conditions. So it's a brave new world, but Europe will lead the way.
Yes, thank you very much. Yes, you are right. these issues are on the desk, and we are thinking about how we can manage this process. Michelle, as you see, I'm particularly interested in data protection authorities' work. And I would ask you, what challenge do you see for DPIs in upholding GDPR Article 23 data subjects access right in AML package?
Yeah, sure. So this is also a new responsibility for data protection authorities, whereas before, the only time I've seen is when a subject access request was levied against a bank or something, and it involved the AML process. Usually the response was, well, this is an Article 6 exceptions, this is under AML and it's allowed. But actually this recommendation goes way back to the Working Party 29 assessment of 4MLD, saying that, you know, how can we ensure that the banks in those processes where they have to keep secrecy, or also known as confidentiality, of the investigation process for potential suspicious activities, how do we keep that secrecy and confidentiality while at the same time respecting people's you know, data protection and human rights. So it was suggested back then that there be some sort of supervision for data protection authorities to go in and see, is this being done, is the process being done on legal grounds? And now we see that that is now included in the regulation. I see, again, much like Nick had said, we're going to need standards and frameworks around how that's going to be assessed. You know, lots of questions remain. Do the DPAs need to understand the escalation path? You know, was this done correctly between the customer due diligence to the enhanced due diligence all the way up to suspicion? Will they have to look at the examination of those processes to determine whether or not that this is being done correctly? And then how much do you then disclose to the applicant? Right? Do you just say, yes, everything's okay? Do you give a little bit more information around that? So that's going to have to be articulated again to keep the confidentiality, because the whole problem there and the aim with confidentiality secrecy is that you don't want to tip off, say if someone is doing something illegal, then they file a subject access request. You don't want to come back and say, you know, give any too much information or even tell them that they are, you know, part of a suspicious, potential suspicious activity report, the other SAR. So there's going to have to be some guidelines as to what are the criteria that you assess lawfulness of processing, how much will you yourself have access to within that obliged entity, and then what is reported back to the data subject.
Yes, it's not easy. And as you said, yes, this guidance is essential. This one rule book for data protection authorities is very important too. Maybe somebody wants to ask something. Okay, we have questions from audience.
Thank you.
Please.
Bradley from Gibraltar, DPA. Thank you for the very insightful contributions. I actually welcome some of the positive remarks made about being better together, these projects leading to the improvement of quality of reporting and quantity, which all gives it a positive angle, positive spin. As I said, I'm very supportive of it, and locally we've actually started doing some work with the Financial Intelligence Unit on areas of common interest. It's welcome because very often the remarks and comments that we hear relate to tensions and conflict. So it's always difficult, it's a problem. Now, you've already touched on resource. Given that you have a DPA and DPO audience here, in the context of resource, sometimes this can be seen as, well, it's just another problem. We have lots of problems, the world is very complex, this is just another problem. So how can work in this area be seen as something that adds value and efficiency to the organization? Because ultimately DPOs will have to go back to the organization and try to sell this to their boards and promote it. How can DPAs see this as adding value to their work? Because we will have to do the same to the commissioners or the commissions. In effect, what do you think is the strategic value of the work being done here to DPOs, organizations and DPAs beyond legal requirements?
Do you have any specific panelist to whom you address your? Okay, yes, please.
So I think that's a great question, because when you're talking to different groups, you always want to appeal to their interests. It's the what's in it for me, question. Why is this important? Why should I devote my limited resources, and why should I prioritize? And so in my talk, I tried to talk a little bit about that too. So like I said, I work on both sides of the fence. So I hear the same things that you're hearing quite often. So first I want to address that. A lot of the misunderstandings comes from not understanding each side, not knowing the business, not understanding the value or how things work, right? And I've been here for the past few days and hearing that on many topics, right? It's like there needs to be collaboration, we need to be educated. And the same thing is true on the AML side. There's a lot of people in AML that don't quite really understand what data privacy and protection is and how it benefits them, because it's presented in a certain way that isn't business, and the businesses have been making money. So I always presented, and in my corporate career, as data protection and privacy, first of all, was a strategic and market advantage. When I am focused on these things that have to do with data quality and improving the processes, I am actually increasing the efficiency of the process, meaning that you don't have to spend as much money as you would had we not done this, right? So you see the improvement, the ROI as they talk about, in the business process. And I think that's something that has to be communicated. I also saw, like take for example, on all of my data subject access requests, saw them as chances to improve, right? Because someone is writing me saying something might not be right. And so I would look at these letters and I would say, okay, what are they telling me? Is it something I have to consider in my processes? And I'd use it as a feedback loop. It was actually a data quality check. And then I would, sometimes that would spur changes, sometimes it wouldn't, but that was the value I saw as the business, right? In terms of data protection and privacy and even, as you can tell, I'm an American. I think I'm the only one in the room. I have been the only one. There's another one. Okay, so we're the minority here but I identify quite closely with the EU principles and always have personally, right? So when I look at how data privacy and protection and what got me interested in this, it was I'm making things better for society, for individuals. We've been talking about the de-risking, right? It's a service to make sure that financial inclusion is a path to better living. If anyone has come from lower income brackets and whatnot, that having access to finance, having access to this information is a support network that you're supporting by making sure that banks, financial institutions, whomever, are doing these processes for the benefit of not only their bottom line, but the people that they're serving, because that's ultimately the customer base. They're very concerned about reputation. That's another thing, right? Is that reputation. They want to be showing that they're doing good, right? Because people are basically trying to advance, you know, good causes. And so data privacy and protection does that. You're helping society, and you're also, and this is no small thing either, the people that AML are trying to target are not very good people. Okay, they're not there to help. They're, you know, and you are calling attention to areas that could be improved, that we could target the people who are hurting society. So there's an ethical bent, there's a helping a process that affects us all, because this is really about growing the health and wealth of your economies and your societies.
Yes, Nick,
I
please.
think that's a really powerful description, I suppose, of you know, that moral imperative and the society-wide imperative for the importance of the threat. I think to complement that, you know, the disconnect between the AML policy and supervisory framework and the DPIA policy and supervisory framework hasn't helped. So it hasn't helped for data protection objectives. The AML CFT system is not going anywhere. It's going to be a really important part of the future of European society. So there's an imperative for data protection benefits to support these design conversations around the future of collaboration in Europe, and to ensure that that system is developing in a way that there's a comfort from the data protection authority community. Just being frustrated, the AML CFT system, people being frustrated with the data protection framework, and the data protection community being frustrated with the AML CFT system, hasn't produced any great results. So there is an opportunity for a sharper, more intelligence-led, more effective system, but it does require that cooperation. I think the other reason why is legal requirement. The policymakers in Brussels, in the first directly applicable regulation in the AML space, it's always been directives before, now it's a regulation, have basically determined that this cooperation needs to take place in all sorts of ways. Collaboration between BPS and PB, as well as the data protection authorities, is written through the regulation. So the political and policy direction and determination in Brussels has required this to take place. Now, a problem is that you don't perhaps have the resources at the DPA level to fulfill that expectation. But that is a problem that needs to get addressed. I think you would also find support from the AML CFT community, you know, the banking associations, the FIU, the AML supervisor, if you are making, you know, a case that actually we need resources here to be able to fulfill this expectation. I think you would also find supportive voices from the AML CFT community that everyone's going to benefit when the DPAs have this capability.
Thank you. And would you like to add something from perspective of European Commission?
Well, just to echo Nick's comments, we've seen how collaboration between AML and DPA leads to a better and more effective use of data. So it's a win-win for both the AML and the data protection authorities. And in terms of being a drain on the resources of data protection authorities, one can also view it as enhancing the work of the data protection authorities. And an example of this is in the AML directive, where supervisors are told that in their outreach to obliged entities, they should collaborate with data protection authorities and ensure that relevant information materials on the appropriate handling of data are given out to obliged entities so that they're instructed about the proper handling of data. So we can look at this new enhanced collaboration between data protection and AML as a means of adding to the effectiveness of data protection authorities.
Thank you, Anne. So Do we have any other questions from audience? Yes, please.
Hello, Irina Gutman, a certified data protection officer. My question is related to the challenge pointed out by Andris, that is the need for some collaborative approach in providing of data protection impact assessments for financial services regulated market. So, what is your opinion? Is it possible such an approach come out in nearest future, or so are there any like works towards this approach of data processing and data protection impact assessments related to AML, data processing in the financial and regulated sector? Thank you.
Andris, can you please?
Thank you for your. Do you hear me? Oh, yeah. Thank you for your question. So it's a very complex question because you know, as I mentioned in my presentation, that basically all obliged entities, let's say controllers, have different methodologies of DPIAs. So this is one of the challenges. From my experience, what I can say, we haven't come to one single methodology how to provide those DPIAs on finance Latvia association level, yes, amongst banks. So we haven't done single DPIA together collectively, let's say so. But you know, from my experience, I can say that we just started this P2P data sharing platform, and we started cooperation within this closed KYC shared utility, where we contracted Estonian company to provide this platform services. So what we're doing, we are exchanging information about the customers with whom we didn't start or terminate the contractual relationship due to ML reasons. So basically, we're now, not exactly now, but in months, we will start data sharing. So yes, we did assessments, we did single assessments for this purpose. So it is possible, but regarding DPIA, no, we haven't done it. And so I would rather seek for the opinion of DPA authorities, just what they think about the possibility to arrange such unified DPAs, because actually, according to GDPR Article 35, the controller, yes, is in charge for providing. Yes, it's not controllers; it's a unified, system, but it's individual controllers. So it's quite interesting how this will be managed, and yeah, and there are very different opinions as well. For instance, in banking area, we have Scandinavian banks. We have Scandinavian only. No, we're American banks, so we have American banks as well. So, and yeah, we have different opinions and approaches. So this will be as well. If even DPA says that it's fine, you can make one unified, DPA. So this difference in methodologies and understanding how to do things, yes, it's quite different. Some banks are just a bit weaker, let's say so, yes, in their capabilities to evaluate, for instance, IT security measures, yes, necessary for implementation of such data sharing facilities or tools, yes. So this is a very interesting challenge. So this will definitely somehow scale the future landscape, definitely. So we must see how it goes.
Just very quickly, I think it's also a great segue to the next session. So we're not starting from a standstill across the European Union. There's been a lot of thinking in some EU member states about AML collaboration and Latvia has had a statutory basis for information sharing, but more importantly, they've had a real process of dialogue between the Data Protection Authority, the AML supervisor, the FIU, and industry on the design of the system. And this has made sure that there's key protections built in based on the Data Protection Authority's advice, and there's a body of insight about the data protection impact assessment process developing in Latvia. We also see legislation in Lithuania, Estonia on private sharing, experience in the Netherlands. So there are some parts of the EU where there is that more advanced thinking on data protection impact assessments, and we do hope that there's opportunities for other EU member states, industry, to benefit from all of that work. That's what we'll be focused on in this next year of research and workshops, is about sharing good practice, highlighting experience, particularly with Article 75 as that develops, but drawing very much from these more mature collaboration environments such as Latvia.
Well, thank you very much, but I can say that we had run out the time and we have to finish. If we don't have any questions, maybe one last question from audience. Yes, please. Here, please. Šeit pirmajā rindā.
Aidan Lopsiger from the Swiss DPIA. I think we all agree that we need less data and more relevant, accurate data. It's a question of proportionality of processing, but I would nevertheless warn a little bit to have only a technical discussion. I think there is also another dimension, the dimension of the proportionality of the whole anti-money laundering system, because of course we can say at the end everybody involved in money laundering is a bad person, which was mentioned. But at the end we have also, in the whole chain, we have also exploited people. I mean the money mules, the small criminals. At the end we have also to watch what we catch at the end of the process. And if the efficiency does only improve in order to have at the end more money mules in the net, then the whole legislation does not really what we all expect. We expect that at the end we have that we can catch the big fish.
I think that this question answered Michelle before. Right data for right purposes.
I think I'll just comment on this and say I think you bring up a really good point in terms of what about the victims, as well, and making sure that that we recognize that there are some people who are caught up in that. They're not necessarily the architects of it. This is a discussion around fraud quite a lot, is where you have people who are being taken advantage and who are being scammed. And then you want to make sure that they don't have their services cut off because, they've been essentially tricked into having their accounts used for illicit means. And so that's something that I think that the industry also needs to focus on too, to protect those people in those situations too.
Yeah, just to say, entirely agreed with the point. And I think Article 75, puts that focus on higher risk linked to national risk assessment. And, these capabilities do need to be used to go after, the organized crime networks and the pervasiveness actually of money mules as a threat. So students, lower income households, are actively targeted by these organized crime groups to say you can get a bit of money, we're just going to use your bank account. And there's going to be an education piece. As with all crime, there needs to be a deterrence that's meaningful, and there needs to be an education piece to help people who are vulnerable avoid the trap of organized crime, and there needs to be disruption of that nexus of organized crime that's creating so much harm, supporting corruption across the society to facilitate their crimes. So I think we can't move away from being effective. We need to be effective and smart, and also be mindful of the vulnerable at the bottom end of this criminality.
So we have to finish today. I invite experts to the last final remark, if you want. And do you want something say to us?
Just to say that the AML package introduces a new era in so many different ways, but particularly in the collaboration between data protection authorities and AML, the AML sector, and it's something I think that is going to be a win-win for both. So I'm looking forward to a closer engagement with our colleagues in the data protection sector.
Thank you. Nick?
Well, I think I've said a lot, but it is a brave new era for the AML world. There's a huge wave of legislation change, which is supporting collaboration. I think we also need to see, that advice and guidance coming in from the data protection authority community. I think this resource constraint issue is a real problem. I think it actually probably needs political engagement to make sure that data protection authorities are able to be resourced to meet the requirements that have been set out by the Brussels political and policy machine.
Thank you. Michel?
Oh, okay. No, I basically...
It's okay. I'm just, again, like Nick, I've said quite a lot, but what I want to emphasize is the mutual interests of both groups. I think that once you find those mutual interests and you sit down and dialogue, that it becomes much easier to overcome any challenges and differences. And I think that really only happens through cross-education and learning from each other. And I think that the regulation, the EU has a chance to really set a lot of standards that are going to be, even more than it already has, utilized globally. Thank you.
Yeah, I don't have in particular good news for DPOs, so we have plenty of tasks and work in front, even with AML regulation. But that's very nice that we can come together and discuss the issues with AML experts. So this is very important. Thank you.
Yeah, thank you very much once again. And I just wanted to say that ensuring compliance is not stay. It's process, and it's never-ending story. We have to ensure compliance every day, because every day brings their own problems or novelties, and we have to stay compliant. But one more thing, that the word of this day in my head, in my thought, is collaboration. It's a main word of this discussion, and I hope we will collaborate a lot. Thank you very much.
Thank you very much for our panelists, and now you all deserve a lunch break, and we will start at 12. And those guests who have to leave to the airport, bus is waiting for you at 11:30. Don't worry. Proceed with the next panel. Next panel the topic we will be talking about will be strengthening AML and GDPR compliance through collaborative strategies. And I will like to ask on the stage the moderator of this panel, Laima Letiņa, who is the Director General for the Register of the Enterprises of the Republic of Latvia. Please applause. And now I would like to ask the panelists to come to the stage, those who are here presented with us, Veronika Sajadova and Marina Krasovska. And we have as well one other panelist, Eduard Hovsipyan, who will be joining us online. I hope he is online. And for this panel, if honestly, me as well, I will be joining this panel. Thank you. But Laima, the floor is yours now.
Hello, everyone, and thank you, Catherine, for introducing me. Well, it's a great honor today to be here, and a little bit of explanation why Register of Enterprises is moderating the AML GDPR panel. Well, nevertheless, although Register is the one who is distributing the information about the legal persons, of course we have challenges also in AML field due to the recent changes in the landscape that, of course, Register is issuing the information about the ultimate beneficial owners who is and still will be one of the main topics during the discussions of implementation of AML regulation and directive, the new package of EU AML law, and of course the both areas, protection of reaching the goals of AML and doing it in a smooth manner with relation to privacy is also one of the main areas for Register of Enterprises of the Republic of Latvia. Nevertheless, a little bit also about my experience. I'm newly elected Director of Enterprise Register and previously worked in Finance Latvia Association, so insight from my side is available also about the financial sector. And with a great pleasure, I'm introducing the panel 6 of this great event about the strengthening AML and GDPR through collaborative strategies, which goes smoothly from previous panel about the navigating through the regulation to how we actually can together achieve the goals of these both areas, because at least I believe it is necessary for society to achieve the goals of both of AML and GDPR, and these are not the two very, very important areas who are living in contradiction. They are supplementing each other. We just need to understand and know how to get the goals reached. I have 4 excellent presenters today who will cover viewpoints of GDPR regulator, data protection officer, so public-private sector already, AML regulator with insight also in the IT security topics, and also EU-level participator who will give the perspective for both areas, AML and GDPR, in the light of how GDPR and AML collaborates to reach the new goals of AML package. We will start this panel with a presentation from GDPR guru, I would say, here in Latvia, and very active director also in cooperation with industries, not only in AML but also with others, who I think no longer require introduction. Please welcome on the stage Director of Data State Inspectorate, Yekaterina Matsuka. Please, Yekaterina.
Yeah, thank you very much. I will do 1 minute, one thing. Michelle. Sorry. Sometimes you need, it's not technical problems, but when you're inside your speech as a lecturer, I can understand that you can forget all your things because you want to discuss on something. So I have different roles today, but one role is present our common work, which we have had with the regulator, which is responsible for the supervising of financial sector here in Latvia. But first of all, when I maybe want to start with a little bit introduction. We talked about it previously, and I talked about it in an opening speech of this day. Very oftenly, we listen to people who are saying that this is a GDPR versus AML or AML versus GDPR, and you always have these two words like contradicting together. It's not like we have one regulation, we have other regulation, and they work together. No. It's always versus. And it's always, and you see this picture of the hockey, it's always where we would put this ball, one place or another. If you want, and in many cases, what we hear as well as the Data Protection Authority from the controllers, that if we will be compliant with the AML, we will not be compliant with the GDPR, and if we will want to be compliant with the GDPR, we will not be compliant with the AML. I think it's still a little bit of stereotype, and I think it's as well our thinking that we cannot combine some things together, and sometimes it's quite hard to combine these things together, but nevertheless, this is possible when you know the purpose. And in many cases, when we start processing or implementation of some regulation, we read it and, we just jump in. We do not look around. So if you have a lake or something like this, you have to look around. You have to understand how deep it is. And then you can find the more risky way. But I think in many cases we all just, okay, we read it, we jump in, and then we will look like how it is. But I think that here, in these two regulations, there's still possibility to have risk assessment and as well have possibilities to implement this together. One thing that is important, and in the previous panel that was said about this new AML regulation, and there is still AML directive. And with this, I would say that one thing which sometimes me as data protection authority representative, I see the lack within the legislation process, because sometimes legislator puts a very like, broad vision for the implementators, and you do not really understand what would be the purpose of some actions. And in data protection, it's very important to understand the purpose. And I think that those people who do not work in the data protection, for them it's very hard to understand what does it mean, this purpose. I have public interests. I do it in the benefit of the society, but then we do not think if actions or activities or some transactions and transmission of the data that we make, which purpose, what results we want to achieve. And here it's quite important to have this precise regulation from the EU level, if we talk about the EU, and as well from the national level, because those countries who are not in the EU, they as well have national law, but even if you're an EU country, you have your national law to implement AML directive. And in this case, in some cases, there is a margins of maneuvers for the member states, and then member states have to assess what kind of processing they have, what kind of risks this processing could be. And in many cases, I go for this direction that is better to allow something and control it than to forbid it, or understanding that it happens, forbid it and say that we just will do not recognize that this happened. That's why in Latvian regulation we have quite precise rules on information sharing, and we put it in the law as there is possibility to create KYC utilities, which is open KYC utility or closed KYC utility, allowing to the controllers to share information, the information which is important for the AML purposes. And these KYC utilities have to be licensed, and the Data Protection Authority is the institution who supervises it and gives these licenses. So it means that at this level, as a governmental, as a state, we say that we allow you to share information, but we create the rules and the scope where you can do it, how you can do it, and we as well have supervision from the first step. And for me, this is a more valuable approach than afterwards for the DPIA to come to the controller to get investigation and maybe get some fines because it's not in compliance. So we check it before it's even started. We check the process as such and purposes as such. That's why I think this legislation rules, which is on the national level of the AML, it's very important. And I think that for our country, we have done a good job when we inserted it in the law. Next one, which is important, is the cooperation between the regulators. As well, I mentioned already these bubbles that we are living in. For us as a country, I would say it's a little bit easier. We are a small country. Many of us know each other, and we can cooperate easily. As a small country, it's easier to me maybe to call to the director of the other institution and have a common vision of what we will do in this area. I can understand that for the big countries, maybe it's less possible, or the countries which do not have mentality of cross-cooperation between the areas. But this is very important because in reality, there is a GDPR, there is AML, there's a controller in the middle who has to be compliant with both regulation, and this controller has both regulators, and each of the regulators comes to the controller and do investigations, and as well tries to put on the controller their own expectations how it have to be done. And some couple years ago, when we were discussing our guidelines, there was a case when the regulator, banking sector regulator, asked for the company the data which, according to the law, have to be deleted. But the regulator asked, do you have a data? And this data was older than, it was, for example, something happened 6 years ago. Regulator asked this data, but institution answered that they, according to the law, they have to store it only 5 years, and they deleted it. And in this case, even with the, even with the demand of the regulator, if the regulator knows that it has this data stored for the 5 years, why you ask for this older data? It means, or you expect that it is 5 years, but still they store it somewhere, and then even as a regulator, you get the possibility that they can store it without after the storage limitation term. So this means the understanding between the regulators, what is important, how to do it, it's very important, and it's very important to have this common understanding. And that's why maybe coming into and talking about all this issue in 2021 already, we understood that we need some guidelines for the companies, for the controllers. And in our case, it was not only two regulators, it was as well private sector. It was the Finance Association of Latvia, which includes banks and other credit financial institutions. So we have done it together. And then when you come together and you start to go for the legal basis, for the basis grounds, for the data subject rights, for what we can do, then you see then, it was quite interesting, this discussion, because there is a data protection authority who says, like, we see it like this. There is a financial regulator who sees it, we see it like this. And there's a private sector who says, oh, it does not work in the reality. And I think you have to, for the regulators, it's quite important to listen to the private sector because they implement it in the reality. So you have to understand what they are doing in the reality in order to say if this is compliant or not. That's why, for me, it was very productive and interesting work, and the work when we all get something new, because finance regulator gets some information and understanding more about what data protection authority is doing and why we expect some rules. Data protection authority understood more the processing, because as well, for the data protection authorities, for the data protection processing as such, you cannot say if this is compliant or not compliant if you do not understand what's happening there. And that's why it's important to understand how this processing goes. From the private sector, I would say it was as well positive impact, because the private sector understood why this supervisory authority asks for something, why they demand some information, some actions from the private sector. So you get the notion of the necessity. And then there was a big recommendation on the framework and how to institutions have to deal, and one of the chapters was processing of the personal data in the field of AML and sanction compliance. So it was a theoretical part with the examples. I would say, and I picked up the most, I would say, important things, and things that we were discussing the most and the longest, I would say. First is a legal basis, and in data protection, everything starts and I would say finishes with the legal basis. You have to find it, and you have to understand the correct legal basis, what you are doing and why. And for the AML, we went through the almost all legal basis, and then we understood that in most cases, for the AML, we can use this legal obligation to with the controller the subject. It have to be in the law then, and then have to be quite clear, prescribed in the law, what does it mean, what controller have to do. The next legal basis that we have, for example, we have in a law obligation that when the bank opens the account for the person, they can ask the copy of the passport, and they store this copy of the passport, and they have to ensure that these documents are always active documents, so it means that they have to implement their actions and measures to say to person that, for example, your passport is expired, please give us the new one. So they have to be always the precise data. But still, for this 100 identification, 100% identification, their banks, they need this copy of the passport, and the law is very clear. You can do it, and there is no maneuvers for the institutions. And in these cases, when there's no maneuvers for the institutions, for the controllers, we say that this is your legal obligation. Another, oh, sorry. And now I see that I have mistaken my presentation, and I'm terribly sorry. I will change it afterwards, because another topic and another legal basis would be exercise in a public interest. And I know that here we have a different opinion through the different DPIAs in the EU, because I know that there is a DPIAs who thinks that this legal basis 6.1e could be used only for the public sector and never for the private sector. In our country, before we have ICJ decision on this stuff, we still can interpret it, I think each of us. So we think that private sector also can rely on the 6.1e if there is a special task or special function which is mentioned in the law, but it's not so precise as the legal obligation. So when the government says to the controller, you have performed or you have to achieve certain quite narrow purpose, but they do not give them amount of data or measures how it has to be done, but the legislator, and for example in Latvia in the AML law, it means that all the purpose of all the actions of the law is to protect the public interest in the finance sector. So in this case, even the private sector, they can rely on 6.1e, but in this case, they also have to have, I would say, a little bit like test of legitimacy. So if this amount of data, they have to still think, okay, we have this exercise in the public interest, we have this exercise and with a clear scope, but for the amount of data what we collect, we have to rely on the other GDPR principles, for example, data minimization principle, and we have to think or how I have to ensure the data is precise. So in this case, this is the responsibility of the controller. If the governmental says to me as a controller that I have to know my client, I have to understand that I can collect only those data who are connected with these purposes, with the AML data, with the AML purposes, or which can lead to open, for example, some infringement or some uncompliances or some unlawful behavior from the person. And in this case, I do not need to collect the number of the children or the number or which home pet I have, like dog or the cat, because it's nothing. It's not connected with the AML. And so, this the controller had to be done by the controller. The next one would be legitimate interest. But legitimate interest would be in the ways, and of course there have to be then balancing test according to the GDPR. But in this case as well, if law is not so precise, but law gives the opportunity for the controller to understand that there have to be additional processings in order to get to achieve this legitimate interest. Consent also could be used, but I would say consent would not be used for the AML as such. But for example, we use the consent more for the person if the person for the KYC utility, it is up to the person. She or he can consent to be in the open KYC utility databases, and he gives this data to the KYC utility, and then it's from one point of view, if you are if you're honest, if you are not infringing the law, it means that you do not need to submit to each bank or each financial institution or each notary one more time your data. You can say that there is a KYC utility, you can look at this data now. So it's easy for the data subject, and he can go this way, but it's his free will if he will do it or not. One thing that as well is prescribed on our national level, but because it's allowed it as well from the perspective of EU law, is the exceptions of the data subject rights. And according to our national legislation, and as well, the things what I'm saying, they are described in the guidelines and with the examples as well, but other things, exceptions of the data subject rights, we discussed very much this topic, to which extent we can implement these exemptions. Because normally for the AML, for the know your clients, institutions collect a lot of data. If you give all the information what it is in the institution to this client, first of all, the client can understand the algorithm, how you do the research, and then afterwards he would know if he would like to be incompliant or infringe the law, he would know what to do in order to avoid some negative decisions on him. Another thing that this information, what collected by the financial institution, could contain as well some commercial secrets, how we do it. In this case, for example, AML law in Latvia prescribes the exception of the data subject, mostly the access rights. So he can access only certain amount of data, but certain amount of data, banks or other financial institutions are allowed to not give to the data subject when performing this access right. Of course, the right to delete data, to erase. You cannot ask, you can ask to erase data according to Article 17, but within the scope of Article 17, and if there is a still purpose based on the legal basis 1661C or E, then this right could not be performed. Nevertheless, exemptions must achieve the purposes and not be absolutely. That's why, for example, for the information which data subject submitted by himself to the institution, and I know that before we had those cases, then controllers, when data subject comes to them and asks about the data, his access data, the institution said, this is the article with the exemption in the law, we will not give you anything. Nevertheless, at the same time, this same data subject, when he submitted some documentation to the institution, he submitted some information. And he already knows that this information is within the institution. So there's no reason relying on the law and saying that we will not give you anything, because he already knows this information. And that's why still, even if there is some exception in the law, those information who already is which data subject submitted to the institution have to give assess and give it back to the data subject and inform data subject about it. And as well, if this is information is from the public registers or from the publicly available sources, as well, this information have to be done. For example, if the institution checks the identity of the data subject with register of the persons, of the natural persons of Latvia, you have to give information to the data subject that you have done it. You process this data. As well, if the information about the data subject is checked in the register of the enterprises, this is a publicly available information, and then institutions have to notify data subject that they really checked him in the register of enterprises. So for the information, this is a more collected with the algorithms of the bank or results, I would say not even data, but results of this. In that case, data subject cannot assess and get information on the results and why the results is like this. But still, there is a possibility for the data subject to perform his rights, and we cannot say that as we have this exemption in the law, the data subject have no rights at all. No, these all rights and exception have to be assessed with the notion and purposes of AML. If the exercising of the rights goes in compliance with the purposes or with the legal rules, then you can have and you can perform this exception. But for me, these guidelines are a continuous process. We adopted them in 2022. It passed 2 years, and I would say what we would need to think and do in the future as well, taking into account that there is a new AML regulation. I would say after a couple of years, maybe 2 years, or now we have 2 years, maybe next year, we have to assess these practical examples that we have and look at them one more time, maybe add in some practical examples, or as well add in some new explanations which comes when we will start to implement new legislation. What I think as well important for the DPIAs, and we as DPIA try to implement it, to be as well involved in the legislation process. Because when the legislator, when the ministers writes the laws and produces the laws, if you are not in, afterwards you read it and you don't understand what to do, but you are still supervisory authority, you have to perform it, you have to perform this, you have to implement this law, or you have to implement supervision based on this legislation. So in this case, it's quite important to be in with as well legislator to first of all showing on the risks of the data protection. So legislator already, when they will adopt the law, they will know what would be the risks from the data protection, and maybe they will take as well different decision. So nevertheless, we have guidelines. We are very proud of it. I can say we can do it. We was, I think, the first one in the EU who had these guidelines from the 2 regulators and private sector. But I think we still can go with them, and it could be like, living document, which could be adopted afterwards. Thank you very much.
Well, next, I think private sector GDPR guru, data protection experts, certified DPO, included in support pool of experts by the EDPB, lecturer researcher Veronika Sayadova, with presentation about role of the DPO in these collaborative strategies and how to successfully implement the GDPR and AML requirements. Please give a round of applause for Veronika.
Thank you very much, Laima, and also thank you to the Data Protection Authority for having me today. So, interplay between the GDPR and AML is one of my favorite research topics. And I remember starting this research years ago with a hypothesis that GDPR and AML actually have these opposite vectors of application. For instance, GDPR requires transparency and information obligation towards data subjects, but AML, on the contrary, requires confidentiality from data subjects. But during the course of my research, I came to the conclusion that these 2 opposite vectors are rather like two hands moving towards each other in order to conclude in a handshake. And only when started preparing for this presentation, I had an eureka moment that this friendly handshake is very much possible thanks to one person, and that is a DPO. Of course, there are many other specialists involved in the process, but in my opinion, the central role still belongs to the DPO. So given that today we have a very limited time, so in order to explain all the tremendous amount of work that the DPO could and should do in the context of AML, I will use an analogy. So if you studied well at school or are fond of Greek mythology, then you remember Hercules fighting a multi-headed monster dragon called Hydra. So my association of the DPO is, of course, with Hercules and not the Hydra. And imagine that the Hydra, the body of the Hydra, is the register of processing activities. So in my opinion, if the controllers would ensure involvement of the DPO, at least in shaping their ROPA, they would ensure that the DPO is properly informed about other related activities so that the DPO would be able to provide support and advice whenever it is needed. So it's like interconnection between the body and the head. You know, the head, the mouth is feeding the body and the body is maintaining the head. So an example, internal procedures. Let's have a look at other enormous amount of different tasks in order to ensure compliance. And these are activities that will be triggered by the answers that you will provide when you will fill out the ROPA. And so without knowing those answers, you will definitely not be able to fulfill all the tasks. Like without knowing what answers to provide in the ROPA, you won't be able to establish proper internal routines and procedures. So let's have a look at those tasks from the perspective of data protection principles. Lawfulness, fairness, transparency. So I already mentioned that AML requires confidentiality from data subjects. But for example, the former Working Party 29 considered that still some general information shall be provided to data subjects regarding the purpose of processing data in the AML context. So please involve your DPO in shaping your privacy policy and understanding what kind of minimum information shall be provided to your data subject. Then, as Yekaterina put it really very clearly, there could be different legal grounds of processing, different purposes. So, for example, if you rely on the legitimate interest, you will have to carry out an additional legitimate interest assessment. So, again, a nice document where to involve your DPO in order to make him creative. If you rely on the consent, so involvement of your DPO would ensure that the consent is GDPR compliant. The DPO also would explain you about the limitations of the further usage of the AML data, for example, for marketing purposes. Data minimization is one of the controversies between AML and GDPR, so you have to answer a very tough question. How much data is enough in order to properly manage the AML risk? And you know, some companies just consume enormous amounts of data and they definitely need a DPO to stop them at some point. Related question with the data accuracy. So what sources of data to use, how reliable they are, whether you are going also to pass on the data, whether you are going to share the data. So these questions might trigger the need for conclusion of additional agreements with other controllers or maybe engage new processors. Storage limitation, by the way, is one of the most popular topics in the European Data Protection Authority's decisions. So the DPO will help you understand for how long you can keep the data and whether it is possible to prolong this limitation period. Integrity and confidentiality, again, is about how to securely store the data, and this can be connected with the conclusion of agreements with the cloud solution, yes, with engagement of a new processor, how to limit and to what extent limit access to data, and who to share the data with. And from the perspective of the accountability principle, you will probably have to carry out a data protection impact assessment, so the DPO can help you to properly assess and identify and assess data protection risks, for example, connected with profiling and automated decision-making, which are going just beyond the legal obligation, or what was discussed in the previous panel, quite heavily, data exchange with the help of the private partnerships. So, and when you have done all this tremendous amount of work, so with the help of your Hercules, and chopped off those heads, which reminds me like striking off the to-do activities, probably you will enjoy peace in your mind, but maybe not for a long period of time, because you might receive some ad hoc data subject rights requests, ad hoc data protection authorities inquiries. You might also experience a data breach in relation to your AML data. And please also don't forget about follow-up and review activities that have to be carried out on a regular basis. So again, quite a lot of work when you could and should involve your DPO. And I would recommend involving your DPO from the outset. As I mentioned, when you just start shaping the ROPA, when you just start identifying the purposes of processing and selecting the most appropriate legal ground, because practice shows that if you engage the DPO at later stages, you might end up with redoing the job that was done before. And that is why maybe for some colleagues, the DPO is associated with the Hydra and not the Hercules. Yes, but otherwise, so quite a long list of activities where you could and should involve your DPO. If you are DPO, well, you saw at least some of them, so maybe you can give it a thought. So have I been involved in those activities and why not? Or if you are like listening as a representative of the controller, so have you involved your DPO in those activities and why not? So you can just reconsider the role of your DPO in the organization. But otherwise, so tremendous amount of work and quite tough job, but exactly this type of job is what makes the DPO a hero. So thank you very much for your attention.
Well, thank you, Veronica, and thank you also for all the Herculeses here in the audience. Thank for your job. I'm sorry, I forgot that I do not have the microphone there, but nevertheless, as I understood, everybody heard me. So thank you very much, Veronica, and all the other DPOs, or as Veronica now mentioned, Hercules is there in the audience. Thank you. And very good advice also to collaborate, not to redo the things. I think everybody hates to do that, so let's take that into account. Next is in line is our AML regulator, the head of fintech supervision from AML regulator Latvijas Banka, with knowledge about requirements also in the IT security field, which, as we all know, sometimes interfere also with the AML and GDPR issues. Marina Krasovska, please, on the stage, the presentation floor is yours.
Thank you so much. Latvijas Banka is a major financial supervisor and regulator in Latvia who covers major financial sector, banking, insurance, investments, digital assets. We will also be appointed as crypto asset service provider regulator when the national law will be approved. And of course, a lot of new types of fintechs that are driven by innovation and driven by new type of technologies that appears on the market are coming to our huge regulatory family, like e-money institutions, electronic money institutions, payment service providers, crowdfunding platforms, investment platforms, and a lot of different other companies who actually create also the ecosystem of the fintechs that are not supervised as they have not to be, like RegTech companies. However, their role in the development of ecosystem is quite crucial. But before I'm jumping into their AML questions on that and a little bit what should be expected and what are expectations in terms of regulation, I also want to show you a little bit more about what are those challenges actually that financial sectors currently is meeting. And major of those challenges, they are focused on rather than on a technology side or a data side, because if you look to how the technologies are developed and the technology and innovation is quite rapid, the dependency of technological park is quite significantly increased, and it will be increased even more because as you see also that new type of regulation are coming, like AI Act that is recently have been approved, different types of other regulations like crypto asset service regulation, MiCA, and that is actually creates additional background and additional floor for service providers to work within financial backgrounds. That actually requires, again, from regulatory point of view, more attention to put into horizontal functions like AML and information security risk supervision. The data protection and customer fraud is a one where a lot of technology is used and a lot of supervision or attention is also applied because it is a cross-functional. Internally, we see a lot of data and statistics, and also it's a question how do you evaluate the data, how you translate the data, how you work with the data. But it always, as a regulator, is important to understand and to measure the balance between the innovation and safety, because customers want to have better UX, easy way to the finance, one click or one-stop shopping. However, if you're going deeply, the solution itself might be compliance. In this sense, the data protection, data privacy, and compliance is one of the important part of any fintech. So there is any financial services, I can't imagine even any financial services that currently is served without invention of technologies. So we have only digital financial services in our playground. In this sense, we're meeting a lot of new types of challenges that are related to cross-border activities from the supervised entities. And they are not only in a traditional financial sector, however, also new financial sectors, the same crypto asset service providers and payment institutions. Well, it has created an additional food for thought. So how would we better to collaborate on cross-border, because there is a European regulation in place, there are other regulations in place in other countries that have different approaches. For example, to take the same crypto area, so European market is quite pioneering, I would say, in this sense. So we have common European framework for that, but the other countries are different. And the companies who are operating in Latvia and servicing their services cross-border and globally, it actually creates a new challenges to oversee and supervise those activities to understand how the reality, the internal control system, always legal and always technological infrastructure, always will be in a major side. If we will look to the banking supervision for all the time, of course, there are liquidity risk are on the head, equity and capital risk are on top. But now the second type of the risk we're meeting is cybersecurity. And actually it creates a new complex of how the companies, especially in fintech areas, are working with the data. And for us, as for supervisors, it's important to evaluate, so is this new type of market players or new types of the service create new type of the systemic risk or not? Because the systemic risk and concentration risk in IT and IML and other topics also quite crucial. But it also creates some challenges for the fintechs themselves, because if we look to what challenges they see that okay, they have huge increase on regulatory burden, not only in terms of AML and GDPR, but if it looks like a typical e-money institution business that will start to issue the e-money tokens. There will be several huge regulations will be applicable to that. And imagine the company who could be actually driven by 12 people should hire the army of compliance people who will care on AML regulation, GDPR regulation, e-money institution payment regulation, PSD2, crypto asset service regulation as MiCA, and on top of that is also DORA. So the question of compliance. Of course, we want to see the prudent and transparent market, and that's why the regulation is created. But also going for innovation and opening door to innovation, we also have to understand that we as a customers will be paying for all those compliance costs. And that is something that FinTech identified right now as the biggest challenge for them. And today is also where a lot of saying about that we need strong regulation and the strong regulation should be in place. So I would say the strong regulation is not enough because the strong regulation is only one part, but we need companies to be strong by themselves, building the internal control systems, building the corporate governance structure, building the risk management culture, building internal cybersecurity culture. When this is in place, it's much more easy to implement any kind of risk-based approach. Because the risk-based approach for all our financial market sectors are in place, but how we cooperate, we are in daily cooperation and in daily dialogue with our industry, with the fintech industry, with banking, insurance, with other sectors, by actually studying and trading them. So what it means to build the internal control culture, what it means to be internal control system in place. And our practice, like practical samples that's showing, so we have created just eight elements of a successful AML complex control system that should be in place in order to create some base for the background for any financial entity who is under our supervision. So, of course, the risk assessment is such. The risk assessment is just a very, very basis of any control system. And, of course, development of the methodology should be in place within the organization. The risk assessment should be developed by their own company. So we quite often see companies are coming for the new licensing process. They are taking different types of documentation. I don't know where they got them, from somewhere else, from the market. Maybe for some not so, I don't know, transparent legal services or whatever, but they even do not delete the name of the previous company there. So this risk assessment will not work for your business process. So and it is actually the data protection question also in place here. But the risk should not be isolated from ABA guidelines, ESMA guidelines, and dependency in which area the company is going to proceed and work. So the strategy of AML and the tone from the top, so it is just a must because it is a compliance value, or it is a major compliance of the company's team and the companies. So there should be no influence of shareholders in daily operations. So the management fit and proper should be in place. However, we also understand that the reporting should be governed in a proper way. And proactive actions and challenges may be taken by the board when required according to the internal methodology and all the risk level and controls that are built within the organization. But of course, the staff responsibilities and the structure it is just a hygiene factor building any control system, and it is important that the structure is clear, it's transparent, and the management is supporting the resources that are necessary to be invested into internal processes that controls any kind of risk assessment like AML processes or information security system processes. So it is just a hygiene factor that must be employed, and all the type of trainings related to AML or data protection or cybersecurity must be in place. So the transaction monitoring, customer due diligence, and suspicion transaction reporting, it is much more. These are three deep areas that any financial lenders are taking into account and have to create all the scenarios, red flags. As a regulator, we are going deeply during our inspections in relation to information security, and we are looking quite deeply into solutions that technically are used by the companies performing these actions. Those RegTech solutions that comes, and all those solutions must be adjusted to the company's business activity. So it should not be like taken away or be hypothetical or be standard. Please do not make this, not use standardized solution. It always should be adapted to the reality of the business. We are always saying the customers, we do not prohibit to work with the high-risk customers or mid-risk customers, but we always say, okay, if you're working with a high-risk customer, so what is your approach to this high-risk customer? How do you control? How do you adapt your solutions to manage the risk with the high-risk customers? And of course, IT system and quality of data is a must. So the quality of data within a system, within an AML process, within any kind of expansion, it's a legal background, the major background, how the major conclusions shall be made and decisions shall be made. So in this sense, when companies are using AML solutions for optimizing the processes or different solutions for optimizing KYC customer processes, it is always important to go through the testing. So the penetration testing, that according to the information communication technology regulation, should be done by financial market participants on an annual basis. The program of your penetration test and the program of the internal test should be always in place. And of course, on top of that, internal control and audit. The internal control and internal audit is a must. So it could be outsourced, it could be in-house. It depends on the business volume, capacity, the proportionality of the business itself. However, without proper way of internal control function, like internal audit, the companies will not be able to identify what are the risks they're exposed to in a major sense. So if going to some practical samples that are where data could be used and AML technologists also helps to identify it within the companies and how we treat and help companies to training them to identify more in a better way different types of risks. One of the sample is just the war in Ukraine started. So if you will look to the data and how it happens, what we started to do, the sanction evasion risks was in place. And we have identified what are the most frequently used risk and frequently used, like say, scenarios, how companies are trying to this evasion. So the use of another jurisdiction, the concealing of changing QBRs, the use of another transactions. So we have prepared and we arranged a lot of discussions with our market participants. We got the roundtable discussions, we got one-to-one meetings, and we are explaining, so what are those controls measures should be taken, how to help them identify those risks by themselves. We have collated different types of data, the open source and internal data also regarding the transactions. For example, here you can see the payment transactions from to Russia and other high-risk jurisdictions. When we saw the tenants, so we used different types of data related to export and import, showing how it is impacted and what are the features that we can see. And you can also see here that in this graph, the largest part of export going to another countries from Russia. So when companies started to use those mid companies, changing the management familiarly and using shell companies in between, everything is visible in the financial world. I mean, everything is quite transparent in the banking right now. And we describe them, so what are our attentions and expectations on regarding how they're taking the control over this new types of the risk. And those typologies, we show them different types of typologies, what we see on the market and how they have to treat it, whether like on advisory basis. And the major idea on that was just a building on a strong internal control system. So as I started in the very beginning, so just strong regulation is not enough. It should be also coming from companies inside. And there are different types of maturity level across the companies. For this purpose, we have several facilitation tools that helps company to go deeply and to understand. We have Innovation Hub, when they got the consultancy regarding the regulation, application of regulation, different by AML licensing process, whatever questions we have open platform for them. We have Sandbox, where they can come and start to test with a limited security environment, the new types of the solution, just to help them to identify what are the risks. And for us as a supervisor, it's important to understand what are the major trends. Do we see the new type of the risks we should be exposed to in the future, and what would be the way how we can manage in order to improve our internal procedures and our methodologies, how we are supervising the companies. We had a lot of open table discussions and collaborations. The market participants are majorly involved when we are working with a new type of regulation or implementation and transposition of European level regulation. So we had legal table discussions with lawyer firms who are serving fintech companies, with the fintechs themselves, and it is important that voice of customer is presented when the regulation on the table and it's open. AML handbook is something we are really proud of. The AML handbook is quite significant. I would say it's like a guideline Bible for the financial market participants, how to treat the risk and how to work on that side. And everyone can actually come to us and ask those questions if they have. And we have a special dedicated teams who are working with the financial market participants. So that will be from my side, and I'm really hopeful that that the companies will start to be more matured in relation to how they're building internal control system within AML, data privacy, or any other risk, especially cybersecurity risks that maybe we'll touch a bit more in the discussion. Thank you very much.
Thank you, Marina, for, I think, not only identifying the challenges who are big and different to solve, but also guiding us through the possible approaches how to really solve them and giving the light in the quite difficult areas we are covering. Well, in our excellent presentation session, last but not least, I will introduce I think one of the rare persons who have read the new AML regulation and directive more than once. It's sanctioned AML regulatory advisor of Euroclear and also member of the European Banking Federation Information Sharing Task Force, Edward Hovsepian. Please, the screen is yours, Edward.
Thank you very much, Laima, and thank you for the invitation, and apologies for not being able to be there in person. Yeah, good afternoon from Brussels. I hope you can also see my my presentation. Perhaps just a few words on the perspective. Yes, currently I work for Euroclear as a financial institution, but in the last few years, I worked as a policy advisor for the European Banking Federation, and as such, I was also involved in the discussions on the then upcoming new ML package involving banks, financial institutions, industry bodies, but also EU policymakers. So I will try to give some explanation on indeed on the new ML regulation. Even if I've read it, I'm not sure that I've remembered everything. But perhaps to be hopefully being able to supplement what was also said in the previous panel. And perhaps just because I was thinking how to kick off my presentation exactly, and listening to Ekaterina and to Veronica, who mentioned in this subject the particular position of the controller in between two potentially conflicting regimes in the GDPR and the AML framework. It just reminded me of a life example I had years ago when the GDPR was just adopted. And the words data protection were a big scare for I would say every controller, including the ML space. And I remember the first case where there was a person who had allegedly, we have been informed that the person allegedly had defrauded certain victims through the accounts of the bank I was working for. So the account was suspended, blocked, and an investigation was conducted. And of course, the person who was blocked tried to challenge, and it was the first time when the a data subject access request was sent in relation to this blocking for compliance reasons. And then remember the tense discussions that we had, because then, of course, it was a new framework, the GDPR, so the data protection colleagues would come to me and ask me, can we review this information? And then I would say no, because we have tipping off prohibitions. But then, going back to what Ekaterina was explaining, does that mean that you don't provide any information at all? Do you provide some information? So this was the first clash, I would say. It was extremely interesting at the time. And perhaps another perspective from more or less the same example, in similar cases related to fraud, we could share information with the institution up the chain. Normally, customers were using many different banks. So when they defraud the victims, they would start immediately transferring the funds to their different accounts in different banks, so that they layer the funds and they lose track. And it always felt we're behind, because we would contact the bank after. So we would be contacted that illicit funds moved to our accounts. When we checked, they had already been sent somewhere else, and then we would inform the next bank up the chain, but they would say, yeah, the funds are gone from us too. So in many cases, these funds could never be retrieved. So I was thinking at the time, if only we had a more comprehensive model of sharing, so that we can detect these flows and that we are not always behind. And from this perspective, yes. You don't see my slides. Let me try again. Okay. Not full screen. These things always happen, right? Okay. Just a second, I will try to do it once more. I don't know why now I don't have the permission to share. So I don't hear you, Lima.
Of that.
Well, perhaps then I can continue like that, unless you can share the slides I had sent in advance. Otherwise, I'm happy to continue.
Yes, the slides will be shared afterwards, so if it's possible, we will continue without slides. But we have slides. Great.
It's a very basic classification of, I would say, the existing ones, and also most of them formalized in the new ML package. The two main models, I would say, is the membership-based model, where we have the partnerships for AML. Now we have a formal definition in the AML regulation. We have a whole article detailing how this should be performed. Then we can go further down this classification on the partnerships in terms of what data they share. But I think for the purposes of this presentation, I'll stick to the more general concept. And then as a separate as a separate model, I would put the continuous engagement, how this is performed. On the one hand, the risk assessments performed at the EU level, also at the national level, which then feed into the individual risk assessments of each institution, each obliged entity under the DMR framework. So this is a more of a non-direct but formalized cooperation. And finally, we would have the ad hoc bilateral model. This in practice occurs when, for example, an institution wants to implement a new software tool, a new technology to enhance certain operations, let's say KYC or transaction monitoring. So this is also the time to go to your regulator, including the DPIA, and to assess potential impacts and mitigate potential risks. And from there, I would move on to the ML package and provide some background now, what we have, what are the main highlights, I would say, but also how we got there, what was our starting point. And as you probably know, mentioned already, this is the first time in the ML framework where we have such section, such part of the regulation dedicated particularly to information sharing. And it was not, I would say, achieved easily, as in the existing framework and also in the draft proposal tabled by the Commission, I think it was in 2021, there was no word, I would say, of information sharing. And the Commission was saying at the time, and also understandable in a way, that the fact that there is no express provision on that does not mean that it's prohibited, and that certain partnerships and information sharing arrangements already exist, which proves that the framework is enabling. The problem was that in the EU, we have different AML regulators, different DPAs who have different opinions. And this is where we had discrepancies, problems, and we as an industry at the time were calling for an enabling framework where pen is put to paper, and that it is clear this is something which can be done, given the right safeguards in place, so which would also be helpful in terms of what needs to be done for the arrangement to work properly. And I would say that gradually the position evolved. Also, the Commission showed understanding, and many of, I would say, stakeholders have a big impact, have had big impact through the work they have done. Existing PPPs, Latvia was one of the countries where they were very active in promoting the arrangements that they had and the best practices. Researchers, we listened to Nick Maxwell in the earlier panel. Banks, of course. So finally, I think this whole push from this wave of stakeholders showed that this is possible, that safeguards do exist, that it can be performed in a way that is friendly, DPA friendly, I would say. And then the putting focus on Article 75, which pertains specifically on partnerships, some main highlights that I would underline. First is that the sharing of information, the way it's formulated in the article, is not a mandatory requirement. Which means, and again, going back to what was mentioned by Ekaterina, I believe, which means that we don't have a legal obligation to share this data. Hence, it's difficult to use this as a legal ground for information sharing. This could be it's a positive thing in a way, because if you have an obligation, then as an institution, you're afraid of a breach, which might lead to more sharing, even when not warranted, so that you're in a defensive way compliant. So we have this wording where members of such partnerships may share information among each other, which shows that there's still some work to be done on specifying the conditions and the particular arrangements for each partnerships. The conditions themselves, they're listed in the regulation, albeit formulated quite broadly. So there's a wide range of information that can potentially be shared. This includes, I would say, both types of AML relevant data. So the one that is related to the identification, verification of the identity of the customer, so the pre-suspicion data, and also data related to suspicion, so the post-suspicion data when it's already been determined that this customer is potentially involved in illicit activities. And finally, the article also provides some safeguards that need to be respected. And I would move on to show the text of the regulation, which appears a lot, but I will not go through everything. Just the basics on the conditions or the limitations to what information can be shared. And you see that it follows a logical flow. So data related to the customer or the beneficial owner, on the purpose and intended nature of the business relationship, on the transactions, and so on. Then perhaps you can move to the other slide where I've highlighted some particular provisions from this article. I think this was discussed already, that those members who would like to become members, well, those institutions that would like to become members of partnerships need to notify their national supervisor of this intention, and they need to verify the compliance, including with the GDPR. And this is an interesting provision because in a way, it requires AML and data protection authorities to speak between each other, because what is required from the partnership is to inform the AML supervisor, who then must consult the DPA. So it's a joint exercise, I would say, of the members of the partnership, but also of the regulators. So it's interesting how that would work in practice. Then on some of the safeguards, a bit from some open questions from more of an ML perspective, I would say. Because the sharing of information can only occur in relation to, and here you have some examples, so higher risk customers for money laundering as identified in national union risk assessments. So here, the question remains to what extent this is risk-based or not, because the union risk assessments and the national ones pertain to certain segments of customers, so not related to individual risk posed by customers. But also there's room for some divergences, because in different national risk assessments, there might be different riskier categories of customers. So thinking, for example, that in some countries, for example, in Bulgaria, tobacco smuggling could be a bigger risk than in Denmark, for example, speaking very, very hypothetically. So this could lead to some discrepancies, particularly in relation to cross-border cooperation, if there is such difference. Then there's one condition, that sharing could occur in relation to collecting additional information to determine the risk score of the customer. So frankly, I don't know what exactly this means, given that once information is collected, then a risk score is assigned. So this could mean that, for example, in cases where the institution is unable to obtain documentation or information which prevents it from determining the risk score, that then they can request from other entities. But it's not sufficiently clear when this would be applicable. And here we see the risk-based element, but it's also a bit broad in its scope, and perhaps there's something that further guidance would be necessary for. The other factor, I think, it's clear customers from higher risks segments that have been listed in the AML regulation, so from high risk third countries, PEPs, shell companies, etc. So these are the limitations, and the last point I would highlight from all this text is the data protection impact assessments. I think this is an extremely important point for the partnership itself before becoming operational. Practical questions there that would arise is who performs this impact assessment, given that there are different actors involved, potentially again thinking of cross-border cooperation. So there's something to be specified either in guidance or in the terms of reference of the particular partnership. Is this conducted internally by an external party, and so on. So there are some open questions, and one point, and I believe in the slides you have it's not mentioned, but a point that is missing in a way is sanctions. Marina also referred to that. More and more nowadays we're talking about sanctions circumvention and the need to share information in order to detect circumvention. In the AML regulation itself, there are some provisions on sanctions compliance that have been included. But looking at the text of Article 75 on partnerships, also of the definition of a partnership, that refers only to money laundering, its predicate offenses, and terrorist financing. So the question remains, strictly speaking, is this not allowed in the context of these partnerships? Do we need a separate legal basis for that? Because these remain two separate frameworks in the end. And looking again at the conditions, the safeguards that information sharing can occur, it could be that actors involved in sanctions satisfy one of the three categories. So high risk customers for money laundering, or from higher risk customer segments, so high risk third countries, etc. But this is not always the case, because often you have a different risk score assigned for AML risks and different risk score for sanction risk. And even customers who are not high risk for AML, for example, I don't know if you have an export or logistics company operating in the Baltics, it's a higher risk of sanction circumvention than somewhere in mainland Europe. So this is another open question. I don't know whether it's because the discussions were quite long on this particular provision. It was one of the last elements to be agreed of the package, and perhaps some questions, some aspects have been missed, and this is to be seen how partnerships adapt to that. And then moving on, it would be Article 76, which I would call the classic data protection provision in the regulation. So this is more applicable, I believe, to the model I mentioned in relation to day-to-day cooperation, the more casuistic side of it. What is new, and that was also mentioned, I think, in the previous panel, the particular legal basis for the processing of special categories of data, of Article 10 data, with a similar wording that institutions or Black entities may process such data. But perhaps as an explanation why this is important to be included in the regulation, because there have been cases in ML investigations where such for example, special categories of data, but also let's say Article 10 data as well, becomes known to the investigator on the basis of a deduction from activities of the customer in question that has been investigated. For example, let's say we have someone who frequently donates money to a certain religious organization, and that information is obtained that this religious organization is connected to terrorist financing, for example. In this case, looking at the data of the customer, we can deduce their religious beliefs, but it's also important from a terrorist financing perspective to be able to process this data. Similarly, I would say for Article 10 data on convictions, which most often in practice this comes from what we call adverse media screening, where such information becomes available from the press. And then we have these, again, safeguards that have been included, that the outcome should not be discriminatory in the cases of Article 9. In relation to Article 10, that a distinction needs to be made between conviction, allegation, investigation. What's the jurisdiction where the conviction has been issued, and so on. But all these provisions, again, are important in terms of, well, having more legal certainty when processing such data, and in the bigger picture of trying to, well, to discover illicit activities. And I would also mention in this article the addition on the use of AI. Again, there are some safeguards that have been included, that the data needs to be limited to CDD information, customer due diligence, that should be subject to meaningful human intervention and should be explainable. And I think this is also extremely important, given that more and more institutions nowadays already turn to AI solutions in different scenarios related to KYC, identification of customers remotely, or transaction monitoring for enhanced capabilities, and so on. So it's important to have in law these, well, the structure, this expectation, what is expected, what is needed, and that makes it easier, what I mentioned at the beginning, to go to the regulator and then together discuss the possibilities. And then moving on to the next part on going forward, what the regulation brings, how this would impact AML and the GDPR compliance. I think that, well, improving the information sharing part is still a gradual process. There are existing partnerships which are different maturity. There are countries where such partnerships have not been set up yet. So I believe it's important to look at what are the best practices across the EU. So we have, as I mentioned at the beginning, the Latvian partnership, which has been quite, as a positive example. We have examples from Germany, the Netherlands, and other countries. We have Summit in Sweden, and so on. These partnerships have been already described in a way in the European Commission dedicated document on the subject. So it's important to identify, to see what other jurisdictions are doing, and now having the legal certainty on how to improve and go one step further. And of course, the need for continued cooperation, that is clear now with the setting up of the new AML authority. I think it's important that the discussion with EDPB is also fruitful in that regard, to address any remaining open questions. And this, of course, implies the DPIA will play an important role as members of the EDPB. And these are some of the open questions that listed below. all the practical aspects on setting up the partnerships, the example I made with the impact assessments and the roles and responsibilities, how the provisions would apply in the cases of cross-border partnerships, the possible discrepancies that I mentioned as well, AML and sanctions cooperation, the question on sanctions, how we incorporate into the existing AML specific wording of the text, the risk scoring, what I mentioned earlier as well, that there might be different risk scores for AML, for sanctions, also for different segments in different countries. And finally, what will be the impact of new technologies and the increased use of AI, particularly in KYC and transaction monitoring. So there's some exciting times ahead, but mainly I would say that it's quite positive that now we have more legal certainty that we can perform such information sharing. There's safeguards that have been listed. So now it's all about the practicalities, I think, and the details on how we do it in an effective way. And with this, I thank you. Happy to answer any questions, and passing the floor back to Laima.
Let's give a round of applause for Edward and each and every panelist. I will now continue with the discussion. Unfortunately, a little time left for that, but nevertheless, I think all of you will agree with me that the presentations were so full with useful information that we have covered at least the half of discussion already. Of course, GDPR requires to protect the privacy inside the data processing, versus AML requires a use of a substantial amount of data. However, I believe that the goals we are trying to reach with the both areas are actually the same. At least if we are looking to practical cases like that, definitely one of the biggest breachers of GDPR regulation are the criminals, like for example in fraud area. I believe they are not compliant with GDPR in any sense of way. So it's good to have a common grounds for both fields and to try the ways how to collaborate. But why we need to do that, and what are the benefits, I will ask for Yekaterina to comment what good cooperation helps to solve, and why is cooperation between the regulators is so different in different countries, what influences whether it will be good or bad, and what will come out of it.
Thank you very much. I think that I touched upon it a little bit in my presentation, but if we're talking about the cooperation, then as well, I would say that this is mentality of the countries. So how the countries are ready to open, and for the institution as well to open. It's not, I think it's not so easy for the supervisory authorities who have independent status, and in Latvia as well, like Latvia's Banka is a very independent institution. Data Protection Authority is a very independent institution, but these two independent institutions will come together, like it's quite hard, I think, emotionally, and because ambitions are high. But I think still, for the regulators, and as I mentioned, even with on this conference, we discussed a lot about the cooperation, because we are not in a lonely island, and we cannot live without others. So if you want to achieve something, we have to cooperate with others. And to cooperate with others, you have to understand why they're doing this and why they're thinking this. And I think that the more regulators would even maybe have some meetings or some discussions on the legislative basis, or after the legislative basis, or of sharing of some good practices, how it have been done, we all will gain from it. And I think not only private sector as a controllers, but society as such, because then we will have one vision, and it does not mean that we always have to agree with each other. I think that it's more interesting and more productive that in the beginning you do not agree with each other, but then in the end you find these compromises. For me, compromises are very good, but I know that nobody is so keen of it. I always say that if you have some problem and you have some challenge, then you have to resolve it, and you have this resolution, and there is no person who is 100% is content with it, then it's good solution and good compromise. It means that you take some part of each side of each part, because if there is in some challenges where different parties involved, one party is 100% content, it means that the others from others is taking something more. So that's why I think that you do not have to afraid to cooperate, afraid to say that our aim is this, and be very open to each other, and only this openness, what we really want to achieve, will as well help us to resolve these problems, because as I understood from the presentation of Edward, we have quite a lot of the changes and challenges in front of us with this new regulation, as well as supervisory authorities. Thank you.
Thank you, Catherine. I think it's a very good message that an ability to agree on a common approaches in the both fields actually creates a huge mess for reaching both goals, and for society as a whole to understand what actually the both regulatory fields strive to achieve, and whether the goals can be achieved at all. So a good point here also for the greater good. Thanks. My next question goes to Veronica. Considering that messages to regulators are delivered by the private sector inside the organizations, you are creating the one opinion. So how would you rate collaboration there between the DPO, between the AML experts, also maybe IT security teams, and what would you recommend to do there to get to this greater good?
Thank you very much. I liked your analogy that about this insider regulators. I very much agree that in relation to the DPO, because the DPOs are being considered like quasi-regulators or mini-regulators. They monitor compliance, they point out some non-compliance issues, and they help to achieve compliance. Maybe the only difference from the real data protection authorities is that they cannot impose those huge fines. But I believe that this is not the ultimate goal of the legal regulation. But the target is, well, you know, if Ekaterina used an analogy with the hockey, so I also would like to use an analogy with the game. If you would like to play a game so that you know the rules and that you are playing fairly. And I think that for some period of time, there was a misconception that there are two games, AML game and GDPR game. But it appeared that we are playing one game, and it is called compliance. And it is one company which is playing this game. And even in this case, it's not like AML team is playing against the GDPR team. Yeah, I think Nick had this analogy with the regulators who has the bigger stick. But in my practice, I remember receiving a question about this battle between the two regulations. Well, in this particular situation, which regulation is stronger? Which regulation prevails? Which regulation shall we apply? So I think it's just in the human nature, the competitiveness, who is stronger, faster, and we somehow apply this approach to our professional environment. But okay, if we want to still think in terms of victory, then that is the company winning compliance, because that should be this ultimate goal. And the teams, they are not fighting each other, but they are cooperating, collaborating, and we discussed about it very much today. So please do not consider each other as competitors, but rather as counterparties, because well, according to the GDPR, you cannot process the data in a vacuum. You need a purpose, you need a context, and AML regulation in that sense provides this context so that you have the justification for the processing. And also what I like very much about these two regulations is that they are both rule-based, they are both risk-based, meaning that these two teams can speak one language. And this is a very good platform for cooperation and finding a compromise. I think that if you start doing that, maybe you will even be surprised how easily this compromise can be achieved. But so tomorrow is a new working day. Just give a call to your colleagues and set up a meeting, and I'm sure that you will find that compromise. Thank you.
Thank you, Veronica. So setting up that different areas doesn't stop us from speaking one language. It doesn't interfere with that. My next question goes to Marine and is about the practice. I would love to hear what is there to offer from RegTech community at the moment regarding, for example, AML and GDPR related solutions. Is the sector growing? And what is happening both in world, in Latvia, regions?
A lot of things are happening in the world. Thanks for the question. Well, what we see right now is that really the number of companies who are developing RegTech solutions are growing. And those solutions are, I would say that maybe first statement would be there is like no borders for IT companies. So if we previously looked at, okay, we have local companies who have been working mainly in our local customers, so there is like, doesn't work anymore in today's environment. And we have a lot of companies who are established in Latvia and abroad and have services in Latvia. So what are the main vectors, I would say, that it definitely is transaction monitoring tools and different types of transaction monitoring tools. One of them are on the blockchain for the crypto assets monitoring, flows, outflows, and in a crypto world, there are plenty of RegTech solutions that are currently available for fintechs and for the banking that deals with not only transaction monitoring, but also the KYC processes, risk modeling, measuring of risks and customer classification. There are a lot of interesting solutions that born also in Latvia in relation to reputational checks. So it is quite important also to checking this and make this process much more smoothly. One another trend is also, as mentioned today, was AI, and AI application within the financial sector is quite heavily. Every year we are within Latvijas Banka approaching all financial market participants regarding what are those technologies that they are using mainly. And we see that our AI is not so maybe highly exposed to, but everyone is already started to do something. Within Latvijas Banka we also have several initiatives within that based RNI. We have data science teams, we have subtech teams who are working in order to do our internal processes much more efficient. And what also is important to mention here in terms of data security and information security is a growing number of cloud technology and clouds. And actually it creates new types of risks, because I would say that half of our financial markets are already in the cloud. And taking into account that also critical infrastructure, saying clouds and transactions and card transactions, it is important to review and see those tools. And for RegTechs, it's also a huge opportunity to be connected into this payment environment to create new types of risk notification tools, reg flag tools, that is based on neural networks. And this dependency of the cloud is growing year over year, and it creates again new vectors for bad guys that actually started to attack not directly only the institution itself, but the cloud and infrastructure institutions and holders. And for us, it's also important when we are going to the inspections, we're also asking and looking at that EU citizens' data are stored within clouds within EU. But in reality, if you look to those EU cloud infrastructure, they all have backups, and sometimes those backups are outside EU. Fintech sometimes overlay on the cloud infrastructure holders that they are doing those backups, but in reality, some of them, at least half of them, are not responsible for that. So the companies that are not matured have to be more attention to their outsourcing services that they are using, and the more we are going deeply, there will be more AI-based RegTech solution. One of them actually recently appeared on the market when created the platform for sharing suspicion transaction and data, not data, but scenarios, different type of scenarios, how to identify suspicion transaction and high-risk customers. And those scenarios could be, due to this platform, be changed between the different financial institutions without data sharing. That actually helps to everyone to be more competitive to using these new types of scenarios that are created by other institutions and to strain the market itself. So those platform-based business in RegTech, I would say, is a good trend, a new trend.
Thanks a lot, Marina, for the very good message that there is both. There is opportunities for ones who are seeking how to comply with their demands with regard to compliance, and both there is new and a lot of new growing solutions how to comply with the demand. And my next question goes for Edward. I hope you can hear me. Can we expect that countries, service providers will be interested to introduce more information sharing solutions on the basis of new regulation? And what circumstances will determine that? How you think?
Yes, well, how to approach that question? I think that the more legal certainty there is in relation to information sharing, the more likely we are to have the door open to more solutions, to more innovative methods of doing so. Apart from the article that we looked at, there's also one other article, Article 74, which in the existing framework included an exception to the tipping off prohibition only in relation to the same customer and the same transaction. Which is interesting because I know of cases where certain initiatives for joint shared utilities or for transaction monitoring could not go forward because the data protection authority would interpret it as breaching this particular article. Now this has been changed as well, so we have another enabling factor. But I think that in general it's a question of maturity, of trust. It will be a gradual process, as I also mentioned during my presentation. Not to mention that the regulation itself enters into force in 3 years. So I believe there would be more providers stepping in, particularly these shared utilities, KYC, transaction monitoring. There would be room for more of those, enhanced cooperation in that regard. As for the circumstance that will determine it, I think that it would be based on best practices to a very large extent to see where this works, where it produces efficient results, improves effectiveness overall. Then that would be an incentive for other countries, for other market sectors to be more involved in that. But that will also take time, and we also need some pioneers in that regard. So on the shared utilities part, we have the Netherlands, who have been also for some years now in discussion with the data protection authorities. So we'll see how that develops. We'll see if there will be software providers creating channels between institutions. So that is also something interesting to see. And I would also perhaps pick up on the AI point again that was also mentioned earlier, that the new provisions on AI would introduce more legal certainty, as I mentioned. So there would be even more appetite, I imagine, from institutions to explore the possibilities to enhance their capabilities in terms of KYC, in terms of transaction monitoring, remote onboarding, to leverage these tools to create more effective outcomes. Meaning effective outcomes in the ML language would mean fewer false positives, more investigation-worthy alerts, more relevant alerts for the FIUs, And of course, by limiting our investigations and reporting to only relevant information, that would also be beneficial from data protection standpoint, meaning that we look only at really relevant data. So again, better for the whole ecosystem. And that is my hope going forward.
Thank you, Edward, for the hope and also for the encouragement for the already existing platforms to share more the information about those solutions who are already created and who can be created in the future. I think very good message there. Well, of course, each and every conference panels is about the audience, the opportunity for the audience to receive the information, inspiration, and answers to their questions. So, question from my side, are there any questions from the audience to our panelists? I see no hands there, so I expect the presentations were really thoughtful and already answered a lot of things you were thinking about. To close the panel, I will ask one of the questions which I at least sometimes hate when I'm being asked that question, but could you please give an answer to a very short question, what you will do to enhance the collaboration more between these different areas we are struggling to get on board with. I will start with Yekaterina. Please, Yekaterina, give us inspiration.
You know, I think that as DPA we do quite well now as well, because we're always open to discuss and to listen if somebody comes to us with some challenges and problems. Of course, it quite, and I would say that what we will do, we always will listen to the controllers and to their arguments. It does not mean that we will always agree with them, but we will listen to them to understand how it is in practice and what is real challenge. Because what I sometimes see in the reality that there's a big problem which is described. It's like big elephant, and people will always try to eat it by one's bite. But normally you do not do it. Normally you cut to the pieces all your food and then you take it one by one. So I think we are ready to listen in, and in some big challenges, like I would say big AML, we are ready to cut it piece by pieces and go step by step. Thank you.
Thank you. I think very clear and good message. Openness and listening and also accepting and giving the feedback. Thank you. Next goes to Marine.
Let's have a call. Well, I mean, in Latvia's Banka, we have created a lot of platforms for cooperation, and we have very good cooperation within FIUs with our colleagues from supervisors from European countries. On Baltic level, we have a special group, we have Nordic group, we have a European group on MiCA, on DORA implementation. Actually, in each and every regulation, we have a specific platform created for information sharing and for experience sharing. In this sense, we also have a good established cooperation with industry and association representation, Finance Latvia, Latvian FinTech Association, Blockchain Association, where they are deeply involved in some dialogues. If someone feels that you have a good agenda on place, so we are very open to any discussions within areas that concerns financial market participants.
Thank you, Marina, for continuing with this positive note. Next is Edwards. It's maybe more challenging for Edwards to answer, but nevertheless, I believe that there is a lot on the schedule for European Banking Federation Information Sharing Task Force. So, Edwards, please.
Well, if you ask me personally what I would do, I think I would follow Veronica's advice. I would speak internally to my colleagues from the data protection department. To have the common vision going forward, but not only there. I think also from the AML sanctions department, we should all speak to each other because now we have these provisions in place, which doesn't mean that we would necessarily use them. So it's important to promote internally, then externally, that now we have these provisions, we have this basis, so let's make use of it. Let's try to enhance our effectiveness in this way. And I think I subscribe to the general message that this is the best way forward for the whole compliance ecosystem, not just GDPR compliance, AML compliance, and so on.
Thank you, Edward. So already a practical outcome from the today's panel. And last but not least, Veronica.
Thank you very much. If I go back to my presentation, and although I described the DPO as, you know, such a superhero, I should admit that the DPO individually, of course, cannot ensure compliance with the AML requirements. And also AML colleagues, unfortunately, they cannot ensure individually compliance with the GDPR requirements. And that is why, actually, a tip that I could share today is that what I do at my work quite a lot is that I'm shadowing my colleagues from other departments. So it allows me to get this perspective of what the colleagues are doing, what is their daily challenges, and actually this is this listening job, which is a very good recommendation. So, you know, there is a saying, if you want to go faster, you should go alone. But if you want to go further, so you have to team up. And in order to ensure compliance from the company's perspective, well, you have to team up, you have to communicate, collaborate. And if we go back to the very beginning of this conference, to the motto of the conference, that better together, I would say that together it is not only better, but it is the only way forward. Thank you.
Thank you, Veronica, and thank you to all the panelists. So let's collaborate. Let's collaborate at an early stage in order not to get too many work afterwards. And let's collaborate also to get the ultimate goal reached. So thanks a lot to our panelists. Thanks a lot for the audience. Let's give a huge round of applause.
I will switch my hats one more time. Thank you very much for the moderator, and I think the moderator as well deserved their applause, her applause. So thank you very much for the panelists, thank you very much for all the lecturers, and thank you very much for those who came here at this venue. We appreciate it a lot because we still think that when you see people, you listen to them in the one place, in the venue, it's more valuable than in online. But we still love people who are online and still online till the 2 a.m. Thank you very much for being with us as well online. And for today and for conclusion of this conference, with this, we close this year's spring conference. And I would want to say thank you to all data protection authorities representatives who was on this conference, to all participants from Latvia who was presenting here today. And I hope that this discussion that we had today will give you new ideas and maybe the spirit of the cooperation, of the listening and of the transparency, and not fearing of each other and not fearing of the GDPR or AML. And maybe while you were going through the Measure Park to your train to the train stop or to the car, think about what you can do tomorrow, you know, to achieve this cooperation level and to make these challenges to be resolved. Thank you very much, and have a nice day. Thank you.